Welcome everybody who's here, those who are joining us in Starleaf. We have Gemma and Linda and Rachel, and then we have Peter who's joining us for his first committee meeting, so we bid him welcome, wish him well. And then we have, I think Robin is going to join us later on in terms of the meeting. Just to briefly, members, go over what's for today's session. There's an oral evidence session with the Lord Chief Justice, and that will commence at 2 p.m. 2 oral evidence sessions with Sina G, the report on child sexual exploitation in Northern Ireland, and an inspection of the criminal justice system's responses. The first with the Criminal Justice Inspector, and the second with the relevant officials on the action plan to address the findings and recommendations within the report. A written update on the delegated powers within the protection from the Stalking Bill, an update on the proposed LCM for the Police Crime Sentencing and Courts Bill, statutory rule to amend Rule 22 of the Parole Commissioners Northern Ireland Rule 2009, and then written papers on a range of issues, including the next steps for the MacLeod remedy for judicial and police pension schemes, the Department of Justice response to the recommendations of the review of hate crime legislation in Northern Ireland, Phase 2 of the review of the PSNI injury and duty scheme, and the proposed consultation on the non-fatal strangulation legislation. So, we welcome those who are with us, and if you want to use your mobile device, as long as they are in airplane mode and all devices are muted, then that will help in terms of everybody being able to hear and no interference. We are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence their approach to the matter under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Have members any interest to declare? Thank you.
You should say I'm disinterested rather than uninterested.
Thanks, Peter. Can we have agreement from members for the oral evidence sessions of Sina G and the Lord Chief Justice to be reported by Hansard? Agreed?
Great.
Thank you. We will suspend the meeting following the completion of the first 2 oral evidence sessions and consideration of the written papers from for a short lunch break, which I hope will be before 1 o'clock, and then we will have the Lord Chief Justice at 2. Item 1 of today's agenda are apologies. I have an apology from Emma Rogan, and I understand Doug Beattie will be joining the meeting at 2 p.m. Linda and Sinead and Rachel and Gemma are joining us by Starleaf, and we welcome them as we've done at the beginning to the meeting. If in relation to delegated authority, Emma has delegated her vote to the Deputy Chairperson, Linda Dillon. Item 2 of the agenda, which is the draft minutes of the meeting of the 17th of June. You'll find that on pages 6 to 16 of today's meeting pack. Are you content that the minutes are a true reflection of the proceedings of the meeting of the 17th? Agreed? Agreed? Agreed, thank you. And I've signed the minutes accordingly. Item 3, matters arising. Items 1 and 2 are the updated committee forward work programme and the Department of Justice request to defer a written briefing paper. And you'll find the forward work programme is at pages 18 to 22 of the meeting pack. Provisional arrangements have been made for the joint committee meeting with the Health Committee on the results of the consultation on the development of a joint secure care and justice campus for children on the Woodlands Lakewood site to take place on Thursday the 1st of July from 1 to 2:30 p.m, with the Justice Committee meeting starting immediately afterwards at 2:30. Details of the arrangements for the meeting will be provided along with relevant papers early next week. So I need to ask formally agreement to hold the joint committee meeting with the Health Committee on Thursday the 1st of July at 1 p.m. to take oral evidence on the development of the Joint Care and Justice Campus for children. Agreed? Agreed, thank you. The oral evidence session with the Northern Ireland Commissioner for Children and Young People on the development of the Secure Care and Justice Campus, the Department's response to the NI Audit Office report on managing children who offend and other justice issues relevant to children and young people has been arranged for the meeting of Thursday, the 8th of July. The Department has asked to reschedule the written briefing paper on the planned transfer of the Appeal Service and Rent Assessment Panel from the Department for Communities to the Department of Justice, which is currently on the work programme for the meeting of the 1st of July. And the Department has asked that that be rescheduled to September, as there are some outstanding administrative and legal issues which are still having to be dealt with. The relevant correspondence is at page 23 of the meeting pack. So are members happy to agree the change to the work programme as requested? Okay. Then the item 4. So is Synergy having some difficulties?
Yes, Chair. Apparently, Jenny are having some technical difficulties in joining the meeting. So if we could perhaps take some of the written papers until we get it solved, that would be helpful. Okay, but we can still, so that was item 4, so we can just move that to item 6. Okay, just bear with me, members, until we get to item 6. And then if you could, Christine, just let me know when they're available. Item 6 then is the Protection from Stalking Bill Delegated Powers. And members, this is at pages 168 to 185 of today's pack. The committee referred the Delegated Powers memorandum, and can I just apologise to members, there's a considerable amount of information here to read, so I'm just bear with me and I will try and go through it as best as I possibly can. But the committee referred the Delegated Powers Memorandum for the Protection for Stalking Bill to the Assembly Examiner of Statutory Rules for a report highlighting any delegated powers to which she wished to draw attention. Following receipt of the report, the committee noted at its meeting on the 20th of May 2021 that the Examiner was satisfied that the delegation of legislative powers provided for in the bill is appropriate, and the exercise of these powers is in each case subject to an appropriate Assembly scrutiny procedure. The Examiner did, however, draw attention to clause 17 of the bill that provides that the Department must issue guidance to the Chief Constable about the exercise of the Chief Constable's functions under the provisions of the bill relating to stalking protection orders or interim stalking protection orders, and may, from time to time, revise the guidance and must arrange for it to be published in such a manner as the Department considers appropriate. The Examiner noted that the exercise of this power to issue guidance is not subject to an Assembly scrutiny procedure. However, in the Delegated Powers Memorandum, the Department states that the guidance will be laid in the Northern Ireland Assembly for information purposes. And she has suggested, that is the Examiner, that the committee may wish to consider whether it may be desirable to place upon the face of the bill a requirement to lay the guidance before the Assembly. To assist the consideration of the matter, the committee requested the views of the Department on the proposal. The Department has responded, indicating that having considered the matter further and upon receipt of legal advice, it is now proposing to rescind from the commitment to lay the guidance in the Northern Ireland Assembly for information purposes, as there is no legal requirement for the Department to do so. So, members, we just want to seek your views on the response from the Department and its proposals that, rather than placing the requirement to lay the guidance before the Assembly in the face of the bill, it will now roll back from that, from its position as it had set out in the delegated powers to lay the guidance in the Assembly for information purposes, and whether we should seek any further clarification from the Department. Rachel.
Thank you, Chair. I'm a bit confused about why this is happening, and I suppose just from previous legislative scrutiny that the committee have done guidance and the laying of guidance and being open about that has been a crucial part of what we have discussed. Indeed, we put that on the face of the bill of the domestic abuse legislation. So I would certainly agree with the examiner's suggestion, and I would like to know from the department why indeed they are resilient from their previous position and part on guidance, and I certainly would agree that an amendment on the face of the bill would be preferable. Certainly would encourage the department to bring their own amendments to the Stocking Bill, but if not, I'm more than happy to explore this as a committee when we get to that stage. And should agreement as a committee not be done, I'm more than happy to propose this myself as an individual member, but guidance is key for any legislation that we do indeed bring forward in any committee, so we certainly have questions about why that decision has been taken.
Okay, thank you. Peter?
No, I'd agree with Rachel in relation to that. It seems to be just the small bit of information we've got back from the department seems to suggest having sought legal advice, that the legal advice saying this is not something which is required or legally absolutely necessary, but simply because something isn't required legally to be done doesn't necessarily mean that it's not a good thing, and it does strike me that it's both standard practice to lay guidance, and also I think in circumstances in which it's not, if you like, directly accountable to the committee or indeed the Assembly, at least having that guidance laid seems to be a very sensible step that provides that level of reassurance. And again, it does strike me that it's a fairly inadequate excuse. And again, I would agree with Rachel in terms of we seek further information a little bit from the department as well. But I think we probably should be looking to amend to put that on the face of the bill, as I said, because if it does seem at least something that would be useful and virtuous, even if it doesn't perhaps 100% legally have to be required according to that. I don't think that's a good enough excuse, to be honest.
Linda?
Thank you, Chair. I don't propose to repeat everything that's already been said, just to say that those points are exactly mine, that we should be asking the department. I mean, it seems such a minor thing, and it is minor to a degree, but if it's so minor, why then not just do it? Will be my view, and why we're silent. So I would like to ask the department why they're doing that, but I do think that if they are intending to do it, then we should put that on the face of the bill, as Rachel's already outlined. We did. This was important to us during the domestic abuse bill. It will be no less important to us during the Stocking Bill, in relation to the Stocking Bill. So thank you.
Okay, thank you, and thank you for the consensus on that. And it's convention and practice, and I just can't understand why it would take a different approach. However, on the basis of those comments, we will correspond back with the department. Thank you. Members, we're going to then return to item 4 on the agenda, and that is the report on the child sexual exploitation in Northern Ireland and the inspection of the criminal justice system's response, the oral evidence with the criminal justice inspectors. The criminal justice inspectors will now join the meeting via Starleaf to provide oral evidence on the inspection report on the criminal justice system's response to child sexual exploitation, and the relevant papers, members, are to be found at pages 25 to 125 of the meeting pack. And can I welcome Jackie Durgan, the Chief Inspector, Dr. Roisin Devlin, Lead Inspector of the Criminal Justice Inspection Northern Ireland, to the meeting, and advise them that the session will be reported by Hansard and transcripts will be published on the committee's webpage. Jackie, as I've just taken the new role as chair, I'm looking forward to meeting with you and working with you and your colleagues, and you're very welcome to today's meeting, and I'll ask you and your colleague to present to the committee, and then we'll have questions. Thank you.
Thank you very much, Chair, and good morning to you and to members. Dr. Roisin Devlin, Lead Inspector, and I appreciate the opportunity to speak to you about the inspection of the criminal justice system's response to child sexual exploitation report published in June last year. I hope the briefing paper that we provided in advance was helpful, and my brief remarks will recap on a few key points. Child sexual exploitation is an issue in our community that we know is happening, but we don't know enough about. But we do know that it is child sexual abuse that needs a joined-up child protection and safeguarding response, and demands a robust response to disrupt more suspects and perpetrators. This includes better awareness across Northern Ireland about child sexual exploitation and the harm it causes. This inspection focused mainly on the PSNI and also the Public Prosecution Service, Youth Justice Agency, Probation Board and Northern Ireland Courts and Tribunals Service and their response. Inspectors from Her Majesty's Inspection of Constabulary and Fire and Rescue Services supported the inspection with their knowledge and experience, including case file reviews, and we also liaised with the Safeguarding Board for Northern Ireland when appropriate. Importantly, we heard from some young people and one parent about their experiences. Some children don't see themselves as victims or perpetrators as offenders. Sometimes the criminal justice organisations have trouble seeing that too. We found some good practice by police officers, prosecutors and others who were dedicated to helping children and disrupting offenders, but actions by police officers to safeguard children and disrupt suspects were not always evident, and prosecutors could not easily identify cases involving child sexual exploitation, and clear guidance was needed. A focus on children assessed as at high risk of sexual abuse were put on a list, while it wasn't clear what action was being taken to protect those deemed less than high risk. As with many complex issues in the criminal justice system, an effective cross-government response is needed to identify and protect children at risk, with clear leadership and strategy that results in good practice and outcomes at all levels. Scotland, England and Wales have made a step change in leadership and clear direction from Secretaries of State that there's no justification for failing to share information that will allow action to be taken to protect a child, and we need the same here in Northern Ireland. This report made 2 strategic and 7 operational recommendations, all of which were accepted. Strategic recommendations centred on the Department of Justice taking forward a cross-departmental response to tackle child sexual abuse and exploitation within 6 months, including targets for the development of a comprehensive problem profile led by the PSNI with DOJ and other statutory and non-statutory partners, improved outcomes, training and a framework for independent joint child protection inspection. Operational recommendations included the PSNI developing a routine quality assurance process for their response to child sexual exploitation with adequate and timely risk assessment and investigation, including child protection investigation. This was to be done by October 2020. Also, the Public Prosecution Service were to further develop its quality assurance of decision making in sexual offence cases, including actively sampling cases, working with the PSNI where a child is a suspect, and assess how understanding exploitation and grooming is reflected in prosecutorial decision making to inform practice improvements. The committee may also be interested to note that we're committed to scoping a pilot joint child protection inspection within the business year and have been working together to progress this with the Regulation and Quality Improvement Authority and the Education and Training Inspectorate. While each inspectorate is independent of each other, we also all see the value in our partnerships and collaborating on such an important issue. I expect it will come as no surprise, given the importance of this issue, that a follow-up review will very likely be included in a future CJI inspection programme. I hope my brief opening remarks are helpful, and Roisin and I are happy to answer any questions that you might have.
Thank you very much, Jackie, and there are members who have indicated that they have questions, and if there's any others, if they just let me know, then we will proceed. But just in terms of an opening question, Jackie, are you content with the response and the actions being taken to address the recommendations in the report, and would you assess that as being satisfactory, or where do you believe there needs to be an uplift or further progress to be made so that the recommendations actually are implemented?
Yeah, well, the Minister advised us that a task and finish group across departments had been established, and I think you're going to hear later this morning from officials about what progress there's made against that. And obviously, when we put a time-bound element into a recommendation, we expect action to be taken, or at least started, within that time frame. So it's something that we follow up on through follow-up reviews, but I think each organisation actively needs to ensure that progress is made and that those accountable for taking action are actually doing that within their own organisations. It is something that we're concerned about, not just in relation to this inspection, but I've also mentioned at committee before about the responsibility on organisations who agree recommendations to take them forward and make sure that they are implemented. But it is something that I think we are certainly encouraged by the commitment that initially has been demonstrated by officials and police officers and prosecutors and others that are involved in this complex issue, and we'll be interested as well to hear this morning about excuse me, what progress they've made.
Yes, and I think that, you know, the issue in relation to this being a complex issue, and it's also a harrowing issue, and as a former member of the Northern Ireland Policing Board, and we will have representation from the police with us later on. Obviously, I have seen the work that they have been doing, but one of the concerns that worries me most, or certainly one of the concerns that among those issues, is that if we go back to 2014, we had the Marshall Report, we've had the Leonard Report, we've had a very worrying NCA, National Crime Agency's latest statistics and figures. And I wonder sometimes, Jackie, and then there's your own report and previous reports, I wonder at what point do we conclude that we are repeating the same things, but that the level of defined actual outcome has improved? Because reports are fine, analysis is fine, but really to deal with this problem, and it's a scourge, and this is not a minor issue, this is a very, very serious and yes, complex issue because it has many facets. But at what time or at what point do we say we've all the reports that we need, but now what we need is not another group, not another subgroup or a subgroup of a subgroup, but it's actually delivery to ensure that this scourge is dealt with in our society?
Absolutely. I think that, you know, the time for recommendations is over. There's plenty of recommendations from, as you've mentioned, a number of reports and certainly this inspection report, and it's now a time for action, and it's a time for effective action across all those government departments and agencies who have input to this, and engaging meaningfully with voluntary and community sector organisations who also have information about what's happening with young people that they're in contact with. And I suppose it is about, as we mentioned in the report, about an effective problem profile to say what exactly is happening here, because it is happening here, and to understand what is going on and what information can be shared about young people who are at risk. So it is a joined up child protection and safeguarding response, but it's also a response to make sure that perpetrators are disrupted and that action is taken against them, and it results in robust investigations and quality investigations leading to prosecutions.
Yeah. And just one final query from me, and then we'll go to members. Do you think that we need a specific offence of child sexual exploitation in Northern Ireland? And is there any such similar legislation which is effective in any other jurisdiction?
Okay. I'm going to bring Roisin in on this one, because obviously as lead inspector, Roisin has a perspective on this. I think it would be good to hear from her on this one.
Thank you, Jackie.
Yeah, thank you. We didn't recommend a specific offence of child sexual exploitation. What we did look at was the current practice, and we looked also at the point you made in terms of outcomes. How have children been helped? And we did find that was difficult to ascertain. One of those reasons was because, you're right, there is no standalone offence of child sexual exploitation, and therefore it was difficult to track cases through to establish what the outcome had been. And that, I understand, is something that was being looked at as part of the broader consultation on the law by the Department of Justice. I'm not aware if other jurisdictions adopt that approach. or what changes there have been elsewhere.
Okay, thank you. And we'll go to the Deputy Chair, Linda.
Thank you, Chair, and thank you to Roisin and to Jackie. And I suppose just firstly to pick up on the point that you had made yourself, Chair, around, you know, reports and recommendations. And to be fair, I know that when Jackie's been before the committee before, this is something that we have raised, and I think that she probably shares our view in relation to not just around this issue, but a number of issues where there are recommendations and you're continuously doing reviews. However, Jackie, you have mentioned that you probably will be doing a review. Will it be very focused in terms of a review of the recommendations, and have they been properly and fully implemented? And if not, why not? And can that be addressed? Or is there something that we need to be doing? For example, if the reason why a recommendation has not been implemented correctly is because, you know, cross-departmental working is not happening in the way it should, or there's a lack of resources, then we as an assembly, we as a committee, we as MLAs across the board need to be looking at that. So would it be as focused as that?
Yeah. Follow-up reviews are very focused on the recommendations made in the substantive report. So a follow-up review would focus on the progress that each organisation had made who had lead responsibility or part responsibility for implementing a recommendation, and that's what a follow-up review does. It certainly would take cognizance of if things had moved on since the substantive report. So if there was a change in legislation or policy or strategy, it would take cognizance of that, but at the same time it would focus on, well, what exactly did these organisations do to implement the recommendations that they agreed to and they signed up to, and are those recommendations still appropriate and current? So that's where our follow-up reviews would focus on, but it shouldn't need a follow-up review. Organisations should have their own governance in place to make sure that there's monitoring at a senior level in each organisation to say, what are we doing with these? We've agreed these recommendations, particularly on this issue, which is such an important issue. If we can't agree and work in effective partnership across all departments and agencies on something like child protection, well then where does that leave us? So this is something that I think certainly is so important. We will be returning to and will be assessing against those recommendations. But I am confident that with the right leadership and with the right sense of momentum and with those governance arrangements in place to say, we're not waiting to be held accountable. Organisations are holding themselves accountable to say, we're going to push this, but if it needs legislation, if it needs resources, then to be clear and upfront about what's needed and the reasonable prospect of having legislation through the Assembly to do this. And obviously there's a priority. We all understand that there are competing priorities for slots for legislation, but as I say, something as critical as child protection and safeguarding in our community, when we don't even know the extent of the problem here, but we know it's underreported, is something that I think if there was ever an issue that government departments need to work in real meaningful partnership across and operational agencies working in true partnership with the voluntary community sector, it has to be on something like this.
No, I appreciate that. Just another two quick points, Chair. The first one is, and you actually did touch on this, Jackie, but just to put you back over it, you know, the report obviously talks about the step change in leadership, and we're not talking about a change in personnel. I understand that, and that has happened, but you know, that there was no such step change here in the north. So I'm just trying to get a wee bit more detail on exactly then what does the step change entail. And then the other question that I have is, the report acknowledges the issue regarding prosecutors understanding the nature of exploitation and grooming, you know, including the existing myths and stereotypes about children demonstrating affection and older children putting themselves at risk and all of that kind of stuff. So I'm just wondering just how serious and widespread that problem is. In that, is it PPS alone, or is this something that you think is widespread throughout the legal profession and the judiciary, and I'm wondering how can we address it. And I mean, I certainly have heard comments in my lifetime, never mind my political lifetime, that would concern me. But I know it is complex, and I know that really and truly, until people, are educated around this issue, it can be difficult to understand, and you can have a view of something, an entirely wrong view, but without somebody maybe sitting down and explaining why it's wrong. And very, very educated and smart people can be very, very, I don't want to use the word stupid, but it's ignorant maybe is the word when it comes to particular issues. And this is one of those issues. And I think that certainly is the case. I mean, we've just dealt with the domestic abuse bill, and we know that it's only really in very recent times that coercive control is being recognised as a form of abuse. People will talk about you're slow to react and why haven't we had this legislation, and I'm sure they'll say the same about child sex exploitation. Why haven't we had this years ago? Because people didn't have an understanding of it. If you don't understand something, you can't fix it. So, I mean, the Justice Committee, and I'm not going to dwell on education, but I certainly am going to be asking the chair that we write to the Education Committee, or the Education Minister rather, on what has been done in terms of education, around education young people about what exactly this is, because as well as those who deal with it not understanding what it is, those who are victims and some perpetrators don't understand what it is that is happening to them or what they are doing.
Yeah, you're absolutely right, and I think I'll address the step change point. I'll maybe pass the point about prosecutors to Roisin, just to say that you're absolutely right. Sometimes I think it's on the wider community, people don't recognise it, and even if they do recognise it, they're not entirely sure what to do about it, because it can look like some young people are acting up or engaged in risky behaviour, but to try and whether it's a parent or somebody they're in contact with through education or volunteering community sector, to try and join all those pieces of information together to say what is the situation with this child, and are they in need of protection, where is the risky behaviour, why is that happening. Sometimes when children become the perpetrators of crime as part of that activity, it's very, very difficult for police officers and prosecutors to discern between that. But it is about a whole of child approach, it's about a whole of system approach, and it's with the aim of appropriately and adequately protecting our children. On the step change point, the content in the report about that was very much a clear message from government, and it happened in Scotland and England and Wales, to say there's no good reason for not sharing information to protect a child. You cannot hide behind GDPR. I think sometimes on the front line people are worried about challenge, they're worried about doing something wrong, rather than having that permission from the top of a department to say, if you have information that is related to protecting a child, then you need to share it. I need to share it in an appropriate way with the appropriate people. And I don't think we've had that message from government. I think we need it, and I think practitioners need it. But I think there is that issue about caution, and maybe sometimes inappropriate caution. So that's a step change that we're looking at and asking for, to say that clear direction across the Assembly and each department, to say here, make it clear to officials and to practitioners, here are the circumstances in which you can share information when it's about protecting a child.
Thank you, I appreciate that.
Okay. If I could also add to that, when we did the fieldwork, one of the things we considered is if there was a strategy here, because that was a recommendation from the Marshall report. And we did consider it carefully, because we spoke to different groups of people. But when we looked, we thought, well, there is a child sexual abuse strategy in England and Wales, and a strategy in Scotland, and we felt really that it was still a gap here. The Marshall report had called for it, and really it was something that was needed, particularly to support people working every day, and to have that leadership and guidance at a cross-departmental and multi-agency level, and to give them the support and working in a complex area. And so that was one of our key recommendations. In respect of understanding about sexual exploitation of children, we also did consider that. We had focus groups with the different agencies, the police service, the prosecution service, youth justice, probation, and we found really that understanding had improved. It was good. There was a good sense of what the challenges were and the complexities, and the fact that children and young people don't often see themselves as victims, and how to get around that challenge. But we also then sampled from a number of case files relating to children and young people within the police and public prosecution service. It wasn't a representative sample, but it allowed us to see in some instances how cases were being progressed. And again, we did find good examples, but also that there could be a better reflection of that kind of circumstance in the decision making. And we pulled out in the report Baroness Louise Casey, her reflections on child sexual exploitation from the Learning in England and Wales, and at that point, which I think is a really essential one, she said the important point about grooming is that it removes any self-determination from a child. There can be no concept of consent to sexual activity where a child is groomed. In fact, a refusal to admit any problem, to protect the boyfriend, to climb out of windows, to run away from those protecting them to the abuser, is in essence the sign of a groomed child. And I suppose what we were calling for was that there is a good understanding of that by those involved in the criminal justice system and their policies and practices, and that it's linked to child protection procedures.
That's great. Thank you. Thank you, Chair, and thank you, Roisin and Jackie. I appreciate your answers.
Gemma?
Thank you, Chair, and thank you, Jackie. I just have one question. Concern has been raised regarding the Department's Income and Advocacy Service for Domestic and Sexual Violence and Abuse, because there's no specific service focusing on the needs of children. What's your assessment of this service, and do you think a child-specific service is necessary?
Do you want me to? I think I'll take that one, Roisin. I think it's a bit early to say. What we have commented on in terms of the advocacy services, as we've said previously, and I think we recently mentioned to the all-party group on domestic and sexual violence, it isn't the service model that we'd envisaged in previous reports. And it still seemed to be a bit fragmented in terms of how victims, their journey through the justice system and when they would get support from various people at various points. But the service is only in its infancy, and I suppose the proof of it will be in the evaluation, and it will be in whether the demand for service versus the quality of the service provided, and make sure that that's informed by users of the service. So again, I suppose it's when you ask about a service specific for children, of course there are different skills engaging with children and supporting children as opposed to adults. And I know that the NSPCC have done some fantastic work in the courts in relation to that, but I think there is something around making sure that the service that now has been tendered and underway, making sure there's a very robust quality assurance review and benefits kind of realisation of that service at an early point, that it doesn't drift on and you get that input from service users. But it's certainly not the service that we had recommended in previous reports.
Okay, thank you. So it's just more or less just wait and see how it goes. And
I think it needs a bit of time to bed in and see what it produces, and I think about the range of, is it meeting the needs of victims and witnesses, and where it is providing services to children, what the feedback is about the quality of that support provided. I think it needs a chance, basically, to be honest, and see how it goes. But I think there needs to be swift action if it's not meeting victim and witness needs. It shouldn't drift on and say, well, we need to do something here. It's not the service that we envisaged, and it's certainly not the joined up service that we envisaged through previous inspection recommendations.
Could I also add to that, at the time of the inspection, Victim Support had begun a pilot for a Children's Independent Sexual Violence Advocate, or CHISVA, I think it was termed. So that had been in place at the time, and we had highlighted that as good practice.
Okay, yeah, I'd be in agreement that if it's not working right, that there will be swift action and don't let it drag on. So thank you very much for that answers, Chair. That's my questions.
Thank you, Gemma. Peter.
Thank you, Jackie and Roisin, for that. I think it's one of the very useful things about your report is the, if you like, the division within the report in terms of the strategic objectives and the operational matters. I think that's quite important. And I just wonder, in terms of the operational side, I suppose from experience, it's quite often that if a challenge is put out to departments to work together, particularly at a high level, that's something I think which is quite often reasonably well done. It can be put together. But obviously, as you highlight within the report, I think particularly at operational recommendation 3, it's sometimes that you can see that sort of high level of cooperation, but it's the consistency of what is happening on the ground that will be of critical importance. And I suppose it's, first of all, to establish, you've mentioned about the issue in terms of implementation of the quality assurance side of things. You've also mentioned about a range of inspectorates working together on the follow-up report. I'm just wondering, particularly in the follow-up report, will there be an opportunity to dig down into what's happening on the ground to make sure that, if you like, the high aspirations that will be signed up to by DOJ and others are actually reflecting a consistency of approach on the ground, and that level of quality assurance on that basis can be obtained by yourselves?
Thank you, Mr. Weir. I think, to be frank, I think that wouldn't necessarily be our experience, where it's easier to address strategic recommendations than operational ones. We would often find that operational ones, where maybe there's only one organisation responsible for taking action, that sometimes it's easier for those to be implemented than those strategic recommendations that need that agreement across government departments, and they might start off well. You mentioned with another, I think the Chair mentioned about working groups and forums to take forward strategic recommendations, but it takes a long time to make an impact, and to say that they've been at least partially implemented, if not fully implemented. The follow-up review will focus on each individual recommendation and give each organisation who is party and responsible for implementing the recommendation to self-assess what they believe they have achieved against it, and then the inspection team would do their own due diligence and evidence gathering around whether that recommendation could be deemed to be achieved or partially achieved or not achieved. In relation to the joined up working with the other inspectorates, that scoping study and planning and discussion with RQIA and DTI about a possible joint child protection inspection, that work is underway, but it is separate to the follow-up review. The follow-up review for this inspection report will focus on the recommendations of this report and would be carried out solely by CJI. But in the meantime, and for us, as each as independent inspectorates, have agreed that we want to work together and show some partnership working in terms of what is the art of the possible, if you like, in terms of independent inspectorates coming together on a relevant child protection issue, and that work is ongoing. It will form part of that framework that we've mentioned as a recommendation for the Department of Justice and other departments to agree through the senior officials child protection group to decide what the framework within the wider child protection framework arising from Marshall and other reports for Northern Ireland. But we're very keen that we worked with the other inspectorates to discuss what might be achievable and delivered within, or at least certainly commenced within, this business year.
Yeah, just to follow up then, I was just thinking as well, is obviously it's a very valuable report in terms of where there are gaps, trying to close those, where I suppose to some extent we're trying in Northern Ireland to get a certain level of step change to bring things up to date and ensure that the response, particularly of PSNI and public prosecution towards child sexual exploitation, is up to date. But I suppose we're all acutely aware that there is always sort of a moving game here, particularly amongst criminals, that what, if you like, would be fit for purpose 5 years ago or 10 years ago is not necessarily where we are today. And if there's any thoughts you have in terms of how PSNI, in terms of their response to child sexual exploitation, can not only just bring themselves up to speed, but as much as possible try to future-proof their actions, because I'm conscious of the fact almost with any improvement in being able to deal with any form of crime, there's always the risk then that the criminals will actually try to be one step ahead again and try to adjust their behaviour to seek loopholes. And I just wonder if you have any thoughts in terms of that, in terms of the response of the PSNI.
Yeah, I think what this report has shown very clearly is that need for that joined up approach from education, from health and social services, from voluntary and community sector organisations. So often the police, the information that they get from other sources is what informs their investigation, and in turn informs a quality investigation file that's passed to the Public Prosecution Service. So the quality of evidence that they can gather and the willingness of people to call out that type of behaviour when they suspect that a child is involved in child sexual exploitation, that there's a sexual abuse issue. And that can come from a number of sources, and certainly, you know, in terms of provision of whether a child is absent from education, from school, or for education other than school provision, where they're not engaged with their usual social groups in terms of organisations that they might be involved in, or they're seeking help from other organisations with their issues. It's taking the collection of all that information and saying, right, does this need a child protection response? Does this need an investigation for criminal proceedings by the police, who in turn will build a quality case file to pass to the Public Prosecution Service and make sure that it is an effective prosecution and that convictions are secured. So I think very clearly this report shows that it's not just a criminal justice system issue. It has to belong to all of us in society, as Linda mentioned earlier, about being aware and educating everybody to recognise the signs and to call it out. But I do think there is something about our community that actually we would be more comfortable thinking that that's not happening here. The child sexual exploitation isn't at the scale that it is in Northern Ireland, and it is about that piece about making sure that there is the profile and raising awareness about what that actually means, that it's not just about a child that occasionally goes missing from a children's home or their own home, because it's not exclusively an issue for children who are looked after, far from it. But how do you join all those pieces of information together, and where there is a concern about the behaviour of an adult or indeed a peer who is involved with a child, what do you do about that, and how do you get all that information together to support the police and the Public Prosecution Service to bring those offenders to justice? Roisin, don't know if there's anything else you wanted to add.
Well, yeah, our strategic recommendation to call for the comprehensive problem profile, and the purpose of that was really just, as you say, to understand what the future risks are, rather than what is known to the police. And key to that was input from the statutory and also non-statutory partners. And the idea of a problem profile is to appraise what everyone knows and what that would tell you about the future risks, and then how to plan for that in order to tackle child sexual exploitation and really eradicate it.
And I think, I mean, obviously one of the major concerns that has been out there during the past, I suppose, year and a half during COVID has been that in terms of sexual exploitation of children, that there will be a number of children who have been very much identified as being at risk, and to some extent there's a level of known sort of quality. It's probably more of a comment than a direct question. But obviously the concern has been out there that particularly during periods where points of lockdown, where people were in the schools, what was happening, if you like, behind closed doors of the families, that no one necessarily sort of knew sort of what was happening. I suppose just as well in terms of the level of knowledge, because we've seen the reports obviously made reference to the fact that all those jurisdictions have created levels of step change in terms of their actions. I suppose one of the other things critically will be the linkages in with other jurisdictions, so that where there's best practice either here or elsewhere, that there could be that sharing of information between jurisdictions, so that if there is some particular piece of action that has proved successful in one jurisdiction, it can then be something which can be applied across others, or looked at least to be applied across others, to ensure that we remain very much at the cutting edge of trying to combat this dreadful evil.
Yeah. I mean, there's any amount of research and strategy and information out there. I think it's the what's needed now is action for Northern Ireland. What's needed is something that is an appropriate and an adequate response to child sexual exploitation in Northern Ireland. But just to pick up on your previous point, what I should have said was in terms of what has moved on, then obviously in the last 5 to 10 years, mobile phone technology, communication methods, whether they're particular apps that children, young people are using, online abuse and the potential for exploitation to be motivated and basically to occur through the use of mobile phone technology and online. So that's something that I think certainly PSNI would be aware of, and how young people communicate with maybe now as compared to 10 years ago, or videos that are put online of children and young people, and how you respond to that and how we call that out, whether it's a parent or a friend or another peer. How do you make sure that children and young people know that it's wrong, that it's an offence, and what they need to do about it, and to make sure that that information is passed when a child's at risk, that there's action taken. So in terms of as society has moved on and the community has moved on, of course, investigations have to keep pace with that. But I think there is that piece about, with any amount of strategies, action plans and grips, and what we need is some outcomes from that, and action taken.
Okay, thank you.
Thank you. Rachel.
Thank you, Chair. Thank you very much for your answer so far in your briefing document. It was very useful, as a lot of my questions have already been asked and answered. But I just want to refer to your document. In item 4.6, you said about understanding outcomes of how children are at risk of child sexual exploitation going to help as a challenge, and criminal justice outcomes were difficult to ascertain. You go on to do about risk assessment process that had been changed and it resulted in a reduction in children being identified as at risk of CSE, and that was between 2015 and 2017. I don't know, maybe one's for our next deputation, but what changes were made in the risk assessment process between 2015 and 2017? And was that looked at as part of the review? And is that the Department of Justice? And is that featuring in any of your recommendations?
The changes that have been made at the time is that it changed from what would have been quite a quantitative scoring process to something that was more qualitative and based on professional judgment. We looked at a number of cases, and within that, the way information had come in and how risk was assessed. And I suppose we had concerns about risks within the assessment being picked up and being responded to by police. at the time, police were working only with children where the risk was deemed to be high, and were not working then with children where the risks were low or medium. And then we also had concerns about when the risk was assessed as high, what kind of work was being done to progress the case.
Thank you. And just maybe don't have the information, but who changed with that risk assessment process? Was that changed by the department? Was it changed within the PSNI? Was it anything to do with cross sort of departments, like with health or anything? Was that just maybe a cultural change? And I fully appreciate going to more professional judgment, more qualitative approaches. But I do think that there needs to be a little bit of a balance then, especially if we have a risk assessment process reducing in the or showing a reduction in the number of children identified over those 3 years. That's obviously quite concerning to have that. So going forward, would you see a more balance then between qualitative and quantitative? Obviously there would be differences between professional judgment, but if the judgment isn't there or it's not picking them up, coupled with the type of work that is being done with children deemed risk, I think there might be still a bit of a problem there.
I think the important point is the risk assessment is joint, so it should be social services and PSNI, and police will be able to provide more detail on how that process is working at the moment. But it was joint at the time, and the key issue, I suppose, for us was how that operated in practice, and being able to pick up on those risks. And our concern was we couldn't really ascertain a routine quality assurance mechanism that would, as you say, pick up on concerns or if something had been missed. And so we recommended that was put in place. And it was actually begun and commenced at the time we were doing the field work for the inspection. And so we do think that focused consideration of cases at the time by a supervisor is important, and one of the key recommendations that we've made in the report.
Thank you very much. Appreciate that. There's a couple of other questions. In terms of data sharing and information sharing, you said about a message from government. Do you think that would be enough to sort of get over if there is a sort of a barrier in terms of GDPR, falling back on GDPR? I appreciate that there have been massive changes to data sharing and data protection issues, and absolutely, we've all had to work within it or learn it. It's a complicated piece of legislation, but we also have the Children's Services Cooperation Act, which mandates departments to work together. Now, I would tease this out at length during the domestic abuse bill in terms of information sharing. But if that's legislation that's on statute there, so for me, GDPR shouldn't be a barrier to this and that legislation. Would a message from government be enough, in your opinion, to kind of circumvent those barriers in terms of information sharing for Northern Ireland?
I think it would certainly help a clear direction and a clear message from the top, but I think obviously it needs to be backed up by awareness and communication and training at all levels in any organisation. So I think it's not something that you kind of would be a one-off. I think it's for organisations to make sure that practitioners are all aware of what they can and they can't do, and if there are concerns and feedback from staff about what's appropriate to share and what's not, that they have support and advice on what they can and can't do. But I do think that a message, the tone is set from the top and the message is sent from the top, and certainly in England and Wales when that happened and the Secretaries of State made that declaration that there was no excuse for not sharing information when it related to the protection of a child. I think that certainly was a bit of a wake-up call for some departments and organisations and their arm's length agencies. to say, yeah, if there is information that should be shared for safeguarding and protection of a child, then it needs to happen. So I do think it's really important, but it's not a one-off event, or it's not a kind of, oh, tick that, it's done. I think there needs to be that constant assurance, whether it's new staff coming into an organisation and practitioners, of saying, this is how we work around here, this is what we do in terms of protecting the children in our community.
Thank you very much. That's all my questions, Chair. Much appreciated.
Okay, thank you to members. On that issue in relation, Jackie, to and you've made reference to it in the report about the use of terminology. Now, I apologise to you because we have only sent you this morning the response from the department, which we should have sent to you earlier, in regards to, they have now given us an updated action log. So what we've done is we've sent that to you this morning, and what we would appreciate if you had a look at that, and any comments that you would have on that, if that could be sent back to us, that would be much appreciated. But obviously
thank you.
This whole issue of the terminology that's used and the challenges that brings, do you see that while it's a small step, but it is something that's necessary to ensure that people are not they have more difficulties, and we continue the trauma via another means in terms of the way in which this is approached?
Yeah, I mean, I think we're very clear in this report. Child sexual exploitation is child abuse, and it needs a very robust child abuse response. I think it is part of that community awareness, and across government awareness, and across agencies and practitioners, and anyone who is involved in this area of work, that they are educated and aware of what child sexual exploitation is and how it can happen, and not make assumptions about children and young people who appear to be acting up or leading chaotic lives or going missing frequently, about finding out what is actually going on in that child's life, and having, as I mentioned earlier, a child-centred approach to dealing with those issues. I don't know, Roisin, if there's anything.
We do make a point about terminology, and during the inspection we were aware of the sexual offences order and how different offences are named, and we had the paying for sexual services of a child and wording like sexual activity with the child. The sense that didn't quite grasp the sexual abuse against the child. And we were conscious of that. And if I may come back to your question about there not being an offence, specific offence of child sexual exploitation here, my understanding is in England that the terminology for one of the offences was changed to reflect child sexual exploitation. And I suppose the important point is that the content of the offences do grasp what has occurred and protect the child. And the UN Committee on the Rights of the Child has called on the government here to ensure that all under 18 are protected from child sexual abuse and violence. And what we found in the inspection, as you probably did see, was that cases may be progressed with lots of different offences around what has occurred. And so it might not always have been immediately obvious to a prosecutor when the file was passed that child sexual exploitation had been involved. And I think what would help there is making sure that is always flagged and made clear to the prosecutor, so that their reasoning and decision can then reflect that. And I know in England and Wales, to help understand outcomes as well, there had been a specific crime flag attached to the child sexual abuse offences, and that was to help build an understanding of how cases were progressing where child sexual exploitation was involved. So I do think that's an important point, and it is a complex one, but one that needs continual focus.
Okay, thank you very much. Can I thank you both for your time, for the report, and for the information that you provided to us, and no doubt we will continue to have an interest in this particular issue, and I trust that soon we'll be able to maybe some good news in terms of legislation that will be of help. So thank you again, and we look forward to continue to work with you. But thank you for your time this morning. Thank you very much.
Thank you very much, Chair.
Thank you. Members, just to conclude before we bring the department officials in, Linda proposed that we write to the Minister of Education just for an update in relation to what's been done in that sphere. And if you're agreed, we will do that. Agreed? Agreed. Okay. Thank you. That brings us then to item 5, which is the action plan to address the findings of the recommendation in the Senate report. And you'll find the relevant information on pages 127 to 166. And can I welcome, I hope, into the Starleaf, the Deputy Director of Protection and Organised Crime Division at the Department of Justice, Cathy Galway, and also Katie Taylor, the Deputy Director of Community Safety Division, Department of Justice. And I think I did see earlier Detective Chief Superintendent Anthony McNally of the PSNI, and also Keir McQuillan, the Assistant Director of Serious Crime Unit Public Protection Services, and Teresa McAllister, the Professional Officer of Safeguarding Board for Northern Ireland. And welcome all to the meeting. I hope I've covered everybody. I'm trying to see everybody that's either in a room or on a screen at the same time, but I think I've been able to identify most people that is there. And just to advise that the session will be reported by Hansard, and the transcript will be published on the committee webpage. Maybe I could invite Cathy, first of all, to outline the current position in relation to addressing the findings of the recommendation. Thank you for the information that you've sent to us, but you may have heard also, we just want to be upfront. We haven't, until this morning, sent that to the Criminal Inspector, so we've done that now, and then they will probably give us some comment following on from that. But Cathy, thank you in anticipation of your comments. Thank you very much.
Thank you, Chair. Can you hear us okay? Yes?
Yes.
Okay, thank you. Thank you, Chair. We're grateful for the opportunity to update the committee on our response to the Criminal Justice Inspection Northern Ireland report on how the criminal justice system responds to child sexual exploitation in Northern Ireland. We thought it would be helpful to briefly set out some background to the collective response to child sexual exploitation up to this point, though we did have an opportunity to hear the previous session, so we will be referring to reports, but understand that the committee will likely have some questions for us about the actual implementation of those. There has been considerable and concerted multi-agency effort to tackle child sexual exploitation in Northern Ireland, going back as far as 2013, both in policy and practice terms, and this was triggered in the main by a police operation at the time. An inquiry was then initiated by the then Minister for Health, supported by the then Ministers of Justice and Education, and the direction to the Safeguarding Board, the SBNI, to undertake a thematic review. In 2013 then, Kathleen Marshall was appointed to lead the inquiry to examine the nature and extent of CSE in Northern Ireland, and consider the effectiveness of current child safeguarding and protection measures, and make recommendations on future actions. That report focused on both children and young people living at home in the community and those living in care. In summary, it found that child sexual exploitation takes many forms and is evolving in line with developments in technology. Professor Marshall confirmed that while child sexual exploitation is happening in Northern Ireland, there was no definitive evidence that it was as organised or on the same scale as elsewhere in the UK. Now, regardless of scale, obviously, there's no room for complacency. The Marshall report was published in 2014, and it made 17 key recommendations and 60 supporting recommendations. And they were made for Departments of Health, Education, Justice, Schools, PSNI, PPS, RQI, and the SBNI at the time. A senior officials group then, made up of Deputy Secretaries of the Departments of Health, Justice and Education, was set up to oversee the implementation of the Marshall recommendations, and regular update reports were produced and published. The majority of the recommendations, ranging from the development of making of legislation, collection of data, production of guidance, revision of protocols, have been implemented, but obviously there is still work to do. As a result of the Marshall inquiry, child sexual exploitation is given the significance it deserves, and it also delivered important changes in practice, for example, the co-location of social workers and police in units. There was then a thematic review of a number of cases undertaken by Professor John Pinkerton, and in summary, it recommended an audit of practice, and the areas for improvement and service provision were then mapped against the relevant recommendations in Marshall. Under the auspices of the SPNI, a follow-up audit of practice was undertaken by the PSNI and the Health and Social Care Board, and this was then followed by the Leonard Review. And that examined the practice of all of the member bodies of the SPNI, including education and voluntary and community sector members. The Leonard report then was published in July 2020, and this coincided with the publication of the Cegini inspection report. Leonard made 14 recommendations for the Health and Social Care Board, trusts, the SPNI, PSNI and Barnardo's. A key finding of Leonard was that efforts to tackle child sexual exploitation should be rooted in child protection, which is a tried and tested policy, procedure and long-established practice of working on a multidisciplinary and multi-agency basis. It also reinforced the message that child sexual exploitation is a complex form of child sexual abuse. Accepting the findings of the Leonard report, a Child Protection Senior Officials Group, which I'll refer to CPSOG, has replaced the Senior Officials Group established to oversee the Marshall recommendations. Its membership has also been extended to include senior officials from health, DOJ, education, finance and communities. The group now has a wider child protection remit and a work plan which includes oversight of implementation of any outstanding Marshall recommendations, the Leonard recommendations and overlapping Cegini report recommendations. The CPSOG has a subgroup, the membership of which extends to the PSNI and SPNI, and it has been agreed that CPSOG will receive regular updates from SPNI to try and bridge that gap between what's happening at a strategic level and what's happening at an operational level. And hopefully that will ensure that our efforts to tackle CSE across departments and agencies are fully coordinated and connected going forward. Turning now to the Cegini report, progress has been made to implement the findings and the recommendations. The report recognised the commitment and dedication among criminal justice professionals and also recognised that the response required is well beyond that of the criminal justice system alone. It called for a strategic framework to support a collective response to child sexual abuse and exploitation, as well as clear leadership to promote frontline practice across the criminal justice system and beyond. The report did identify gaps in practice, and the inspectors made 2 strategic and 7 operational recommendations to enable a better criminal justice response, and we welcome that. An update on the departmental response to the recommendations was provided to the committee in September 2020, and the associated action plan was then shared with the committee in January 2021. The paper for today's session also provides an update on progress to date. In terms of the recommendations, the majority are operational for PSNI and PPS, and I hope you can see from the detailed update that progress is being made. There are also a small number of recommendations for Probation Board, the Youth Justice Agency and the Northern Ireland Courts and Tribunal Service, and those updates are also included in the briefing paper. As well as the recommendations, the report also identifies areas for improvement which are being taken forward by the relevant business areas. Just turning very briefly then to the strategic recommendation, the first recommendation highlights the need for cross-departmental strategic response to tackle child sexual abuse and exploitation, which is linked to any existing and future plans for child protection. As you can see from the briefing paper, and as I've set out earlier, the Child Protection Senior Officials Group is a cross-departmental strategic forum which provides direction on existing or emerging child protection issues that require cross-departmental coordination and consideration. So in responding to the Cegini recommendation, it was important to consider the potential for duplication that may have been created if another structure replicating existing partnerships was put in place. Rather than creating another forum one that DOJ would lead on, it has been agreed that the refreshed CPSOG is the appropriate forum for ensuring a cross-departmental strategic response to tackling child sexual abuse and exploitation and ensuring alignment with future and strategic plans for child protection. The recently updated terms of reference, which was included in the briefing pack, hopefully provides reassurance to the committee that this group will provide the necessary strategic direction that has been discussed and highlighted in the report as needed. The first strategic recommendation also refers to the inclusion of targets for the development of a comprehensive problem profile and improved outcomes, and work is progressing to develop this. PSNI colleagues are working with analysts to identify and capture all the information required to produce this comprehensive profile, and Anthony can hopefully provide more detail on this aspect of it. The recommendation also refers to multi-agency training, which is also referred to in the Leonard report, and SBNI has a plan to establish a training and communication committee to support multi-agency collaboration. In terms of the final part of the recommendation, the framework for independent joint child protection inspection, and Jackie and Roisin talked about this, the CPSOG subgroup are working with inspector colleagues in justice, health and education to develop an enabling framework for independent joint child protection inspections. And we agreed recently that the recently established subgroup from CPSOG will produce a detailed scoping paper for a pilot to be tested by CGINI, RQIA and the ETI. A detailed scoping paper and action plan will be presented to the next CPSOG meeting to progress and support this important work. So, as well as ensuring we play an active role in cross-departmental approaches, the report also provided an opportunity to consider how we in the Department of Justice coordinate the response to tackling child abuse and exploitation strategically across all of the various areas in the department. We've recently secured an additional resource to scope this work and provide an oversight for the areas identified in the CGINI report and in terms of broader concerns about vulnerability and harm. Chair, I'm not going to go into the second strategic recommendation. You have the detail in the pack, and through the CPSOG subgroup, we will be monitoring those actions and how they're delivered and implemented. In terms of the operational recommendations, each partner agency is leading on the actions identified and work is progressing well. And given the overlap with the Leonard recommendations, the work to progress some of the CGINI recommendations will be progressed by the SBNI subgroup on CSE, which Anthony chairs. In summary then, Chair, responding to the CGINI report provides the opportunity to develop a more comprehensive departmental approach to child protection, which not only encompasses CSE, but wider vulnerabilities, for example, how young people are also exploited through the coercive control of criminals and paramilitary groups. As the briefing paper highlights, actions are being taken forward to address the recommendations, and while we might not have met and have not met the timescales set out by CGINI, significant progress has been made over the last year, and we also acknowledge, though, that we still have a lot of work to do. I hope that update has been helpful, and we're very happy to address any questions that members have. Thank you.
Thanks, Cathy, and I'm also glad to see on the call. As a former member of the Policing Board, I very much appreciate the work that has been done and led by Detective Chief Superintendent Anthony McNally. It's good to see him on the call, and we'll bring him in maybe in a minute or two, because really, I suppose, the concern I have, Marshall Report 2014, here we are, 2021, and we're still talking about, and I know there's, and I do appreciate, Cathy, the amount of work that's been put into the response that has been given to the committee today, and the various strategic work that has been going on. But if you were a victim of child sexual exploitation, or the parent of a child who was subjected to that, or a family member or someone who knew about this, would you really have any great comfort that a report and then subsequent reports and subsequent reports on reports has been all carried out, and there's a plethora of paper, but the problem with child sex exploitation is on the increase? And I think when we saw figures a few weeks ago from the National Crime Agency, it is harrowing what is going on nationally in the nation and locally when it's brought down to proportionality in terms of Northern Ireland. But there is one thing that I just want clarity on. Well, number, but we'll deal with this one. The Child Protection Senior Officials Group. Did you say, and I think I picked you up right, that has now been expanded? Because what I saw was there was a small core of departments involved, and then the other organisations were in a subgroup. For example, the PSNI wasn't on the officials group, but it was on the subgroup. Has that now been changed, and has that group been expanded?
So, Chair, the CPSOG has been expanded to include other departments, and then the CPSOG has also, as part of the task and finish group to look at the Leonard and the Cegini recommendations, that has now become a subgroup of CPSOG. So myself and Katie would sit on that, Anthony, Teresa and others. But what has happened now is that CPSOG has agreed that it will receive updates from SBNI, from the chair, and receive practical updates about what's happening on the ground. So previously there was the strategic approach, and it was departments talking to each other, and it was mostly education, health and justice in terms of implementation of Marshall. That has now expanded into other departments, and the CPSOG subgroup will be advising the CPSOG senior officials group about what's happening on the ground. So in terms of the information that's going to CPSOG, it will hopefully be a lot more informative, and also we will then be able to bridge the gap in terms of how that informs and influences practice on the ground, and likewise how practice can inform CPSOG of issues that need a collective and coordinated departmental response.
Can I ask Anthony just a question as a practitioner? And apologies for that very broad term, but someone who really is in the front line of a lot of this, and your officers who have to deal with this, sadly, along with other of your colleagues from the criminal justice system. Andy, do you believe that there's now a need for a specific offence of child sexual exploitation, which will be helpful in terms of dealing with this problem?
Good afternoon, Chair. Good afternoon, members. I knew you would ask me that, Chair.
You know me long enough now.
Yeah, I suppose, through my lived experiences of the past number of years in public protection branch, we see the challenges where things are unclear and there isn't specific legislation. And I think the example that this committee is particularly familiar with is the Domestic Abuse Bill and Will Be Act. We did have challenges around, we really only had harassment as an offence specifically, which could or could not be used in a domestic abuse environment. But by having now a specific offence for domestic abuse and a further specific offence of stalking and harassment to follow, I've put on answer to this committee that I see the benefits of those to policing in terms of having clarity. That clarity also, I believe, allows greater understanding across agencies of roles and responsibilities. It also allows for greater accountability across agencies and within agencies. So, as a basic principle, I could understand how legislation would be very beneficial. But at the same time, Chair, I also note the words that have been used here this morning by yourself and others in terms of critical, multifaceted, complex, complicated, and writing legislation to cover this would equally present those challenges. So not trying to sit on the fence, I can see the benefits, but I can equally see the challenges in terms of trying to write such legislation. But if it could be written, then certainly the PSNI would consider it a significant benefit in terms of how we could work with partners.
Kieran, would you want to comment on that? Because obviously the relationship and the interaction between yourselves and the police is a vitally important component part of all of this. Would you have any comment to make in relation to the issue about the specific offence?
Thank you, Chair. Can you see and hear me okay?
Yes, we can. Yes.
What I would say on the issue of a specific offence is I would echo what Anthony has said, that clarity is very important, and obviously there could be challenges around the drafting of any such offence. We certainly see that the sexual aspect to child sexual exploitation, the offences within the Sexual Offences Order, the 2008 order, do generally cover the activity that we seek to prosecute, and we feel that all of the aspects of it are contained within that. But the challenge, and I think the report set this out, is drawing out those aspects of exploitation and particular features within CSE. So if an offence could be drafted in a way that captures the offending activity, whilst highlighting those aspects of CSE, that is something that we would certainly look to use, but we would be very conscious of not maybe diluting the offences that are already there. So I'm afraid I'm probably going to sit on the fence alongside Anthony there, but I do think that if it could be drafted in such a way as to assist us, we would certainly use it.
Okay, thank you. There's a list of members who are now wanting to ask questions, so we'll go to members, and I'm going to try and take these in the order that I've got them. So first we have Gemma Dolan, and then we'll go to Peter, who's in the chamber with me. Thank you. Gemma.
Thanks, Chair, and thanks everyone for attending and for your briefing. Can I start with Cathy? Cathy, can the department give an update on what further work has been carried out in relation to reversing the burden of proof in relation to the defence of reasonable belief?
I'm sorry, Gemma, I don't. I'm not in a position to give an update on that. But I'm wondering, would Kieran, does Kieran have any input into that? But I can certainly get an update for you. But I'm just wondering, does Kieran have anything to add?
I wouldn't have any input into the legislative process, obviously, but I'd be conscious that that would be, that would be quite a dramatic change to the way in which these cases are prosecuted. I know that there's a lot of academic research going on, and there was a very useful academic event last week which I took part in through a number of different academics in Queen's and elsewhere. So I'm conscious that it would be a significant step, and there would be challenges in it. It certainly is, the burden is on us as prosecutors to discharge, but whether the legislation is going to be brought forward or not, I can't speak to that, I'm afraid.
Okay, thank you. Cathy, if there is any work going on, would you be able to find out?
Absolutely, I'll check that and get back to you. Okay,
thank you. And the other question, this is probably for Anthony and the department. The progress update on the comprehensive problem profile of CSE is welcome, as the outcomes it will lead to are very important. But can you indicate a time frame for when it will become operational?
So Anthony and I discussed this yesterday, actually, in terms of a time frame, and so probably around the autumn time, maybe. The work is ongoing. I think the key thing is, and reflecting on what the inspector said earlier, we will be working with the PSNI in terms of supporting that work and also ensuring that work is progressing in line with the recommendations in the Cegini report. But I know maybe Anthony could give a bit more of an update from the PSNI perspective.
Yeah, of course, happy to do so. Gemma, yeah, it is ongoing. So we agreed in terms of reference in February. It took us a little while through COVID and just with sort of changes in personnel in various agencies to get to that point. So those were agreed in February in terms of what we would look at. So we're kind of looking at it from a problem analysis point of view in terms of what do we know about the victims, what do we know about the offenders, and what do we know about the locations where CSE is occurring, and digging down into each of those areas in terms of what information do we presently know across our agency. So things like, what was the background of the child? Did they live at home? Were they looked after accommodation? Were they a boy or girl? What type of offending was occurring against them, and so on and so forth. So it is, by the very definition, comprehensive. As of the end of May, start of June, we had completed the sort of data gathering, if you will, and again, to do that across the criminal justice sector, but also into health and education, was challenging just through to different IT systems and so on. But being the lead on it from the PSNI perspective, very grateful for the support of others, not least Teresa, who's on the call from the SBNI to help us get that information. So we've got all of that information now, and it's now a case of working through it. And as Cathy said, the first cut of that I would hope to have probably by early autumn. That may or may not be the finalised product, depending on what it looks like. We may need to go back if there are certain gaps. But we hope, as Jackie Durkin said earlier, we hope that will help us understand what gaps in knowledge we have, and help us from what we do know determine then what we need to do next. And I think that all feeds into it. And I think even that in itself may be an important thing to understand in terms of future direction around legislation and so on. So hopefully that gives you a bit more detail and an assurance that that work has progressed, because we all collectively recognise the importance.
Yeah, that's great. Thank you very much. And my other questions were about CPSOG, but you've touched on them already. So thank you very much for that. Thanks, Chair. That's me as well.
Thank you. Peter?
Thank you, Chair, and thank you to Cathy and the team for the presentation. I suppose I just want to touch on two aspects which also raised, I suppose, with CJI. Cathy, it was very good to get the action updates, and I suppose it's good to see the steps that are being taken in terms of implementation of the report, both at a strategic level and also in terms of the action log. Obviously deals with some of the actions that are getting taken on an operational basis. And I suppose first point just want to probe is, obviously in terms of implementation, we're seeing what you've outlined is actions that are getting taken both within the department in a wider sense and across, if you like, the wider sort of justice family, if I can put it that way, and also actions taken in terms of trying to tie in on a cross-departmental level to get that level of input as well. But I just wonder, in terms of, you could maybe update us, in terms of combating the violent crimes of CSE, what work is going on in terms of progressing actions on a cross-jurisdictional basis? And I suppose really I look at that on two grounds. One, as we see in different jurisdictions, it is about trying to ensure that we're all sort of adopting best practice when tackling the issue of CSE, but also on the grounds that while I think for the vast majority of crimes will be quite localised in their nature, we'd be aware sometimes of particular predators who will look across different jurisdictions, will maybe just seek to exploit weaknesses, exploit loopholes, if they feel that maybe one jurisdiction is not being at quite the same level as others. So I suppose my first question really is if you can maybe sort of outline not just what's happening across departmental basis, but what linkages are there in terms of being able to progress issues on a cross-jurisdictional basis.
Okay, thank you. And yes, so at a policy level, we would engage with our policy colleagues in the other jurisdictions to understand what's happening in terms of serious and organised crime, and CSE and child sexual abuse would be included as part of that, and we would be docked into some of those UK-wide meetings and official meetings to understand emerging policy and what's happening elsewhere. And as I said earlier, Peter, we're also we've now got a resource in the Department of Justice to make those connections, not just within the department, but also with other departments. And we recently engaged with our Home Office colleagues around their new child sexual abuse strategy and their disruption toolkit to try and understand what's happening elsewhere. But you're absolutely right. I mean, while this could be a local problem, and I'm sure Teresa and Anthony will want to say something about the prevalence of it locally, because of the online exploitation, you know, an abuser can be from anywhere. So this has an international dimension as well. So we do try and keep ahead of the threats, and we get regular updates and assessments from some of our partners, which are shared with the police. So at a policy level, we are engaged with the other jurisdictions, but we still have some work to do, because the resource that we have in the department to do this work about having an understanding and scoping out how we connect across our own areas where there's legislation, Gillen on Kitty's side and on Brian's side in terms of the new offences and things like that. We still have some work to do. So we're starting off in this journey to get more connected and to understand more. But because I'm responsible for organised crime as well, I would be involved in all of the serious and organised crime groups that with the Home Office and colleagues in Scotland and Wales as well.
And I suppose just following on from that, because obviously appreciate particularly now as we're moving into a fast-moving era in terms of online, this can be international in its nature, but I suppose also just looking at the physical practicalities, and maybe this might be more, I suppose, in terms of the practicalities that maybe Anthony may be in the best position to answer. I presume as well in terms of that level of close coordination and work is also happening between ourselves and the Republic of Ireland, where obviously there's a physical border, but that obviously then doesn't act as a boundary point.
At a strategic level, you would have the joint agency task force that works on a cross-border basis, but in terms of investigations or operations, maybe Anthony could come in there to talk about how they cooperate across jurisdictions.
So I'll maybe just touch on the online space first as well. So there is a Home Office and National Police Chiefs Council led Prevent and Pursue board that looks at the online space in terms of online CSE. There's no doubt that it has significantly increased since 2013, and that's no different here in Northern Ireland. Be that whether the victims are in Northern Ireland or whether the perpetrator is in Northern Ireland preying on someone else across the world, which we of course have seen. So those two forums significantly are looking at how do UK government work closer with legislative requirements and so on around the multi-corporations, Facebook, Twitter, as to how they report this, how they try to stop it from getting onto their platforms in the first place. So I'm sure you'll have seen the online White Arms paper and such documents. So there is a wealth and depth of activity trying to support the online space across the UK. That's also supported in Northern Ireland by the Safeguarding Board, who have dedicated subgroup specifically looking at e-safety, which again is chaired at the moment by Police Detective Chief Inspector Guy MacDonald, and Teresa was represented on that as well, I believe. So within the SBNI, it's one of the subgroups with a specific focus to try to look at it within Northern Ireland specifically. And that goes back, it talks to the point that Jackie made around, do parents and children know what the risks are and how to avoid them? So there's been a significant amount of work done in that space. And again, just to touch on, I think it was Linda mentioned a point, again, education are represented on the Safeguarding Board and are a member of the CSE subgroup of the Safeguarding Board, so are very much alive to the risks. So there really is a collaborative approach both within the UK and indeed within Northern Ireland in terms of the online platform. Cathy touched on the Joint Agency Task Force, and of course that's something between herself and Garda Síochána. On an operational level, those things will just happen by nature in terms of we have connectivity with the Garda on a daily basis around any of these things that we need. We have in the last number of weeks dealt with investigations with a cross-border aspect where children have maybe gone missing in the north and are suspected to be in the south, and those relationships are very strong through my own public protection branch. But hopefully that gives you a sense of sort of the strength and depth of the collaboration both across the United Kingdom but also with our colleagues in the Republic of Ireland, but specifically here in Northern Ireland.
And I think sort of I welcome that. I think I think you made very important points as well in terms of education, particularly of parents, because it's not even in terms of, say, some of the threats and some of the changes that are happening from the point of view of online or sort of apps that will be on phones, that it's not even simply that there can be a bit of a gap between generations. It's actually the fact that if you're, the position 5 years ago, or indeed children at a particular age 5 years ago compared to where they are today, even sometimes older siblings can be in a very different position. Can I just ask, I suppose, the final question then, just again, it's very welcome that there's action being taken in terms of implementation, but I just want cognizance in terms of the implementation as much as possible is being given to try to make sure that what is being put in place is as future-proofed as possible, because obviously we're in a fast-changing environment, and I think there would be a certain level of missed opportunity if simply we are very successfully everything is implemented and then found by the time it's implemented to a certain extent it's either out of date or alternatively at least is limited because there isn't that examination of what from a practical point of view should be done to sort of try and future-proof actions against the crimes.
Well, I mean, this is a very dynamic area, and you're right, it does change all the time, and trying to stay ahead of the threats. And as someone said earlier, offenders and criminals are agile and innovative, and they will find ways to exploit any situation to their advantage. And it's trying to ensure that we have an assessment of the risks, and CPSOG does have a work plan and a way of ensuring that we are keeping up to date with what's happening, and that we are. So implementation is one thing, but we need to, I don't think we can sit back and say, well, we've implemented those recommendations, that's the end of it. I mean, there's ongoing work particularly I think at the SBNI CSE subgroup, and I wonder maybe if Teresa could give a bit of an update on how we try and stay ahead, working with police and social services, how we try and stay ahead of the threats. I think you're on mute, Teresa.
Thank you, Kathy, and thank you, Chair and members. First of all, can I just maybe give a bit of background in terms of the CSE subgroup in SBNI and its representation from the various agencies, just to give the committee some reassurance that this is absolutely multi-agency. The CSE subgroup within SBNI is chaired by PSNI Anthony McNally, Chief Superintendent. We've representation thereon from the Health and Social Care Board, the Health and Social Care Trusts. We have a regional social work lead who sits in her own right, who manages 5 social workers who are really quite specialist in this area of CSE and are co-located with the PSNI. We have representation from the Youth Justice Agency, from the Probation Board of Northern Ireland, from the Education Authority, and representation from the NSPCC and Bernardo's. So the CSE subgroup has been really operational now from 2013, and it's a fairly dynamic group. It meets bi-monthly. Coming out of that, we have various task and finish groups that are associated with, I suppose, developments that are coming from those frontline staff, those practitioners, those police officers, as they are experiencing them. We connect in very strongly with the online safety forum that Anthony has just referenced, that is also supported by the SBNI, and Chief Inspector Gary MacDonald, who chairs the online safety forum, also sits on the CSE subgroup, and there is also crossover with the Child Protection subgroup. That is a group of statutory directors hosted by the SBNI as well. So we're trying to join all those dots across the different areas. We're trying to make sure that there is improved connectivity from those operational staff, those practitioners, middle managers, up to the various departments. I have to say I'm a member of the CPSOG subgroup, and I find that a very dynamic and a very useful group as well in terms of sharing what's happening across the different departments and operationally. And I've also accompanied the independent chair of the SBNI, Ms Bernie McNally, to the CPSOG, and I certainly can assure that that's a fairly interrogative and it's learning experience, but it's certainly we are absolutely accountable to that cross-departmental group.
Okay.
Yes, sorry, thank you. Yes.
Okay, thank you. Rachel.
Thank you, Chair, and thank you to everybody for their answers so far. a number of my questions have been touched upon, but Teresa, just because you'd mentioned it there about the group and feeding in with frontline services, and I had a question just with regard to the likes of NSPCC and those that are taking, I know of friends that work within their helpline, and I know certainly over COVID the number of calls had increased incredibly, which was extremely worrying and concerning. But on a variety of child protection issues, but specifically on CSE. So just how do the likes of those frontline services feed into the groups, and then also into just the wider system, especially with the department in terms of policy? Is there a mechanism for that to happen?
Well, certainly the regional CSE lead sits on the CSE subgroup. She's a lady called Sheila Simons, who's a senior manager from the South Eastern Trust, and she directly supervises those 5 CSE leads are based across the 5 local health and social care trusts and co-located in the police stations with the PSNI leads on CSE. The Chief Inspector MacDonald and Chief Superintendent McNally obviously are also in the CSE group. So we are receiving that information directly from those 2 key frontline practitioners. We have representation from the Education Authority, who will feed up their sense of what is happening and their experience of what's happening within specific schools or sectors or whatever. Obviously, our Deputy Chair is the NSPCC Director of the CSE subgroup, so he can feed into that what's around, and certainly Bernardo's, who offer some therapeutic work, specialist therapeutic support for children who have experienced CSE, are directly involved in that and can feed back. I suppose, though, the presence of all that kind of grouping also allows us to hook into what's happening nationally in terms of across the water, and in terms of not only practical but academic research. We would have relationships with Bedfordshire University, where Helen Beckett leads in this area, and she has been assisting with the development and the ongoing development of the assessment tool that I know you referenced earlier in the previous presentation. So we're trying to ensure that we have the best practice that we can have, and that is benchmarked across other jurisdictions as well. I should also say that the Online Safety Forum links directly into UKIS, and we have one of our members from Education Authority actually sits in that UKIS group in London, and that directly feeds back. We receive an update. We have representation actually from UKIS on our forum as well. So we get an update at every meeting from UKIS directly, and then from the Education Authority who sit on that group.
Thank you, Teresa. I really appreciate that information. My next question is, I suppose, just bringing it right back to the Marshall report. It's probably one for the department. The Marshall report, obviously published in 2014, as you'd referenced, but were all those recommendations implemented? And if not, are they pieces of ongoing work? Or have they sort of been subsumed into the various other reports that we've had since 2014?
No, there are still open recommendations from Marshall, and we can provide an update on that if that would be helpful, Rachel. For those that remain open, implementation is underway, and for example, there is there's implementation underway in terms of cross-border information sharing protocol, and that's nearly complete. So I think Health are leading on that, so we could get you an update on that. But there is a table that sets out the Marshall recommendations, which ones have been completed, and those that are still open. And I'll see if we can share that with the committee.
Thank you. I think that would certainly be quite helpful, just to know where we're at from a number of years ago, and in relation to what work is ongoing on that. And finally, from me, Chair, and it was just mentioned there, we discussed the importance of data and information sharing when it comes to CSE and child protection. And so Jenny had stated that a message from the top, as it were, plus training and awareness and support for practitioners and those working with people on this. and ensuring that they know that GDPR or other data protection issues are not a barrier to information sharing when it comes to child protection and to CSE would be beneficial. So I suppose for Anthony, maybe it's another one for you. Would that be beneficial? Do you think that would be beneficial? And then for everybody here, do you see GDPR and data protection issues as a barrier to information sharing on CSE as it stands at the moment? Or has there been any changes since this Sagini report was done? And anything that maybe we need to work on as a committee? Do we need to get a message from the top to say that's not a barrier and that information sharing is okay in these circumstances?
I have no concern with that message coming from the top. Like always, it's welcome because it reinforces the importance of such things. If the Assembly or this committee were minded to do so, I'd certainly obviously be supportive of that. In terms of the sort of the practical answer to your question, in terms of GDPR as a barrier, I don't believe GDPR is a barrier at all. I believe most people have a good understanding of that specific piece of legislation now, but I do believe that there is still at times operationally a fear around information sharing, or sometimes just through new staff coming into post and maybe just different interpretations of the information sharing agreements. We do hear occasional concerns about it. So as such, from both the justice side and the health side, through Elise McDaniel, we have met to talk through those. There is a revised information sharing agreement. If it's not signed off, it's very soon to be so, with health and police in this very specific area around child abuse and information sharing and that. And our intention is always to work that through in terms of making sure the practitioners understand it, and indeed by way of reassurance specifically on CSE, because it's one aspect of child abuse. The PSNI and health colleagues, the 5 leads within the trust, as was referred to by Teresa, were actually all together yesterday in Garnerville, just catching up. It was the first meeting pre-COVID face-to-face, which was fantastic. Again, when staff change, it's difficult to build relations, as we all know, just to reaffirm our professional boundaries and commitment to work with each other. So there will always be day-to-day challenges, but certainly I don't believe there's a barrier within the legislation. And it really is about just good partnership working, and I think that should be fine.
Rachel, if I could just add that information sharing is on the CPSOG work plan. It's one of the priorities, so the Department of Health are leading on that. So that's probably the work that Anthony's referring to, that will go to CPSOG. So there should be something coming out that will be CPSOG endorsed.
Rachel, yes?
That's it. I could go on all day, Chair, but I'll not.
Okay, thank you. I don't want to not give you the opportunity. So, and then finally, the Deputy Chair, Linda.
Thank you, Chair. Like Rachel, I have so many questions that I'm really struggling to limit them. But a couple of just points to make at the start. I was glad to hear about the link in with Education Authority and the fact that they're feeding stuff up, and I would hope that, as well as schools, and I would imagine it is coming through youth services as well, because they link in very much with those most vulnerable and attached children, particularly youth services that go out and engage, do the street work and that kind of stuff. So I think that that's really important. But I think it's important also that that there's feeding both ways in terms of information, so that works both ways. So if there is examples of best practice, in particular on what you're talking about, and again, you've said that the Education Authority are the link there with Across the Water. If there's best practice in other places, then we need to make sure that we're using that. And we need to make sure that youth services are getting any information around information sharing and the different tools that they might be able to use. I think that is vital. And across the board, not just youth services, obviously it's for the voluntary and community sector as well, right across the board. I think that is vital. Safeguarding board, and in terms of CP dog, I do think that there does seem to be a fair good representation. And to be fair to yourselves, you were the first ones to raise with me around Operation Encompass, and I wouldn't let go of it until I got it in somewhere. And we finally got it into the domestic abuse bill, which I was really happy. But again, that information sharing was the problem there. It was the blockage. So there is a real concern around information sharing, and it's vital. So just in terms of your own piece of work and what you're doing around that, if there is things that we need to be doing, and I said this at the time around Operation Encompass, the things that we can do or need to be doing, that's what we're here for. Just contact us. You don't have to wait until a committee meeting. There's no problem with contacting the committee directly in writing or whatever way that you feel is necessary, and saying, here's the problem in information sharing in this sphere. Help us. See what you can do. Find a way around it. I do think that's vitally important. And just on that, Anthony, this is probably one for you. We're talking about information sharing across departments and organisations, but the report was concerned in that where high risk of CSE regarding child has been identified, important information and intelligence isn't being reported anywhere on a police system. So if that child comes to attention, say for example that the previous history, that there's concern around a particular child, and then that child goes missing on a particular day or night, and local community police officers are sent out to find that child, find the child. Where were you? With friends? Okay, that's fine. Return to home, safe and sound. No link up there, nothing. Is there anything being done to address that? Because that, I think, is vitally important. If within the PSNI there isn't that information sharing or ability to do that, then how are we supposed to do it effectively across organisations? So I'll probably let Anthony come in on that first, and then come back to the other questions, if that's okay.
Yeah, sure. Thanks. Question. I suppose first of the sort of the strategic information sharing. I do, and like has been said here, the extension of the CP SOG to having that subgroup, and therefore police and health attendants and so on, is so important, and we're very grateful that link is there. I do think it makes that connectivity between the operational and the strategic much better for us all to feed into. In terms of the operational aspect of your question, we've done a significant amount of work in the past, it is 12 months actually, since that report was released. Time flies. In terms of the operational side of it, policing, the way CSE was structured was we are co-located, we have co-terminus boundaries with the 5 health trusts as our partner within public protection, but we had CSE officers within each of those areas. Their supervision was local, so there was no sort of coordinated work within public protection branch. That has changed. I have implemented 1 inspector and 2 detective sergeants who have that helicopter view of what's happening across Northern Ireland. And indeed, they're held to account by me at a daily morning management meeting at 9:30 as to what has happened in Northern Ireland in respect of those children who are identified at risk of CSE. That happens every day now. And then on a monthly basis, we have a performance meeting around, how many children have we safeguarded? How many people have we arrested as a result of this? How many notices have we taken out in terms of calls, ratios, and those type of preventative orders that we have in play? At a very sort of operational level, those things are in place now. I can expand that into the partnership arena because, as I mentioned, the 5 key leads within health and social care are so important in respect this. And again, since COVID has lifted, the benefits of being able to work more collaboratively are very much in play. So not only did I have my CSE officers and the health and social care officers together about 2 weeks ago up in Newforge, we also had offender managers within PSNI and representatives from our rape investigations, because again, some of these children are bordering on that age, and some of the people offended are offending on potentially children and those within that adult environment. So that was operational recommendation 3, I believe. Linda, from memory, I'll have a quick look at the operational. Yeah, within 6 months, the PSNI implement a consistent approach. So as far as I'm concerned, we have done that, and we have a really robust and good structure, and hopefully that reassures you on a very operational day-to-day basis.
It does. I appreciate that. That's very helpful. I mean, again, I know that we have some really good people in all of the organisations who have been really good at working together for a long, long time. It's just that we're only now at the top level and cross-departmentally catching up, and in some areas not catching up.
Linda, can I just add, it would be remiss of me to say, so Kieran and I also now have a coordinated meeting together, and we've agreed in terms of reference around serious sexual crime. And one of the challenges that was put forward by St Jenny was quite rightly around the quality of files and how those files are passed to the PPS. So again, for reassurance, where there's serious sexual crime, Kieran and I are now meeting on a frequent basis and making sure that we are doing all we can to make sure our staff are working collaboratively with file builds and all those things to make this as swift and effective as possible to get justice for the victims in a timely manner.
Okay, I appreciate that, Anthony. Just speaking to Kieran, and that my next question is for yourself. I did ask this question of Jackie Durkin around the PPS and their understanding of the issue, and wider than PPS. Whenever I was speaking to Jackie, to be honest, I was asking how wide did this problem go? Was it general within the judiciary? And that's the understanding of the issue, the myth busting, the training around what, child sexual exploitation is, and particularly around those issues of, young adults who display inappropriate behaviour themselves, that it's almost the child's fault, Yeah. So, and I know this is a really complicated and complex issue, and without proper training, without proper education, it is difficult to understand exactly what child sexual exploitation is. But it's vital that the people who are going to be, bringing forward prosecutions understand it better than anybody else. I'm just wondering what has been done in relation to that, or is it an ongoing piece of work, Kieran?
Well, I agree absolutely. The importance of tackling those myths and those misconceptions that are out there. In terms of what's been done, the unit I head up, the Serious Crime Unit, which was set up in 2016, major part of our work is serious sexual offences, and contained within that would be the child sexual exploitation cases, those ones that come into us. And I would say, and you might say I would say this anyway, but I would say, and I think the report did say, that there was good understanding within our unit of all of those sorts of issues, and they don't impact on our decision making adversely. But we accepted when the report came out that we need to support all our prosecutors across the organisation to make sure that perhaps if they're dealing with, for instance, a victim of CSE who might be a suspect in a case, that they understand that their behaviours might be influenced by the exploitation or by the circumstances they find themselves in. So we're developing that guidance. We've got a range of things. We've got proposed amendments to our code for prosecutors. We've got a draft safeguarding policy, and we're going to develop that guidance for prosecutors. As to the wider legal world, probably, I can only maybe speak for the prosecution service. Certainly it is encountered when we bring forward prosecutions. Gillen, you'll be very aware of, has a large section dedicated to tackling what I've described rape myths, but a lot of those can cross over into the CSE world as well. So, we're doing a lot of work. We're doing work with other stakeholders and with the Department of Katie around the Gillen implementation. But as far as CSE, I think it is very important that we tackle those sort of behaviours that perhaps a jury, or perhaps maybe prompted by some of the way in which defences are conducted, might make misconceptions about, that we tackle those, and that's what we're trying to do.
Okay, I appreciate that, Kieran. Thank you for your answer. It was just my final point, and it'll be no surprise to anybody in this committee, because I probably say the word education more than I say justice in this committee, but I don't want there to be victims. I don't want there to be perpetrators. I want us to educate our young people so that they don't end up being either. And the chair has already agreed that we will write to the Education Minister in relation to what has been done around education on this issue. But I suppose education goes wider than that. So what is being done, or what is being developed in terms of educating us all as to what child sexual exploitation is? Because if I wasn't in this committee, would I be as informed I don't know. You know, if I'm being honest about it, I don't know if I would. I suppose it's something that I probably would have an interest in anyway, so I might be, but no, I'm not sure that I would. And if somebody in my position who is in the Assembly and who is making policy and legislation and, you know, trying to be part of protecting children and creating a better society for everybody, doesn't understand it, then how is everybody else out there supposed to understand it? So that's probably something for the department, because I think there's a piece of work to be done there around, you know, and I suppose in a simplified way, and I know that this is not a simple issue, it's extremely complex, so how do you make it simplified? But there has to be some way of doing some kind of a really effective campaign out there so that people understand it when they see it. You know, the same as we have to do around domestic abuse, to understand it when you see it, but around child abuse, to understand it when you see it, coercive control, you know, I think that we need to do something around understanding it when we see it.
Linda, thank you. I'm happy to take some of the points you've raised there. I think certainly Kieran's referred to some of the work that the Gillen team are taking forward on this, and I think you're right to point out that when we talk about education and early intervention and prevention, it's important that we don't limit that just to schools and curriculum, but there is an important role there to play, and you'll be aware that the Minister has met with the Department of Education previously to talk about getting a piece of work taken forward that looks more specifically at what RSE in our schools looks like, and thinks about both in terms of sexual offences and the issues around consent, but also healthy relationships more generally. And I do think that that will be a good starting point in terms of filtering through on a more societal level around that sort of bottom-up approach to healthy relationships, consent, and all of those issues. Gillen also, and apologies, I don't lead on the implementation of Gillen, but I'm aware through broader work on sexual harm of some of the recommendations in there, and there is a recommendation in there around raising awareness of the issue of sexual offences more generally, but that will of course encompass child sexual offences, and I think there are some good lessons potentially to be learned around the forthcoming campaign on coercive control that you referenced, and what works actually in terms of shifting attitudes and raising awareness on these very important, but as you say, quite discrete issues that people might just not be in the public discourse, and sometimes it's simply a case of getting it into the public discourse and getting it talked about more widely and more broadly. So I suspect there will be some lessons from that campaign that then can be fed into the work the Gillen team are doing around awareness around sexual offences more generally. Certainly we've had some successful campaigns in the past. This needs to be a sort of multi-pronged approach. So you've got talk to children early, but get the societal discourse and messaging going as well, because until there's a conversation about it, it is something that tends to sort of stay behind closed doors, or as you say, something that people don't think about until they are directly confronted with it. There's also, I think, for the more professional element of it that you referenced, Kieran has talked about what the PPS are doing. The Gillen implementation team also have a training subgroup, which is led by the CEO of Victim Support, which is looking at what are the training needs right across all of the various justice agencies, including the judiciary, to think about those issues around sexual offences, myths, jargon busting, all of those types of issues. Again, not specific to young people, but will incorporate issues specifically around sexual offences for young people. So I completely agree, and I think there's a multi-pronged approach needed, and I think there's some good lessons we can take from other areas of the department that might help here as well.
Thank you very much to all of you for your presentations, and just going to take this opportunity to pick you up on what you just said around public discourse, because I've been thinking about this as this conversation has been taking place, and I really wish that our media out there would stop picking up on some of the nonsense and start picking up on issues like this, because if they were reporting on this and we were having these types of conversations and it was part of the public discourse and was out there on media platforms, I think that that would make a real difference. So maybe if any of them are listening into the committee here today, they'll pick that up. And I don't really care how they do it, as long as they do it, if they're getting this conversation going, and obviously appropriately. But I do think it would be really effective. I think you're right. That's exactly how we will will make a real difference if people are hearing about it and talking about it. So thank you to all of you, and thank you, Chair.
Thank you, Linda, and thank you to the members for the questions. And on that final note, I think there is something maybe, Cathy, it would be interesting to know from the department's point of view, that we have seen other departments who have carried out very successful media campaigns. Some have been very hard-hitting, whether it was in relation to the activities of paramilitaries, or whether it's in relation to domestic abuse or speeding or whatever. And maybe there is a consideration that should be given to a media campaign, because, as Linda says, we all need to be educated, re-educated and informed in regards to what is going on in our communities and in our society. And I think if people saw that in a very stark way, sadly, I think it would have a different perspective in terms of maybe the information that would be made available to actually bring the perpetrators to justice, but also to give comfort to victims that this is not an issue that's being ignored by society. So can I thank you all for your collective and individual contributions to this, to Cathy, to Katie, to Anthony, to Kieran and to Teresa. Thank you all for your time today, and we look forward to continuing to work with you in the time ahead. Thank you very much.
Thank you, Chair.
Thank you. Okay, members, I think there was nothing coming out of that. We've agreed that we write the Minister, so that's the only...
Yeah, we've agreed to ask Jenny for their views and comments on the action plan, so when we get that back, the committee might want to consider...
Okay, thank you. Members, if you will indulge me now for a few moments. I said I had stuff to read earlier on. I have even more to read now, because we have a few statutory rules and a few issues. So if you just bear with me, we will go through this as efficiently as we possibly can. That brings us to item 7 on the agenda, which is the Police Crime Sentencing and Courts Bill proposed legislative consent motion. The committee has been considering the provisions within this particular piece of legislative consent motion from the Assembly, and will be required for some time now, and has sought the views of the Northern Ireland Human Rights Commission and the Attorney General, including on compatibility with the European Human Rights Convention. The meeting on the 27th of May, the committee noted the response from the Department to the issues highlighted by the Human Rights Commission and the Attorney General, and agreed to refer the responses to the Northern Ireland Human Rights Commission for further views and comments. Further response has been received from the Commission, and it highlights some areas that the committee may wish to consider further or seek further clarification on, and draws attention to several areas that the response from the Department has not addressed. The committee has also agreed to request details of any engagement either the Department or the Home Office has had with the Northern Ireland Office, the Department of Justice in the Republic, or the powers to seize evidence relating to the location of human remains outside of a criminal investigation, including the potential implications on the work of the Independent Commission for the Location of Victims' Remains, and whether there is a possibility of overlap in jurisdiction. The Department has indicated that the Home Office has not engaged with the NIO or the Department of Justice in the Republic, but is of the view that the draft provisions do not impede or undermine the work of the Victims' Remains Commission. The Department has brought the provisions to the attention of both departments, and they have not made any comment and have not raised any issues regarding potential implications. The Department of Justice has also provided an update on the current provision or the current position regarding the proposed legislation consent motion following its consideration by the Executive. The Executive has agreed for the provisions relating to the amendments to the Crime Overseas Productions Order Act 2019, enforcement of Scottish sexual harm prevention orders and sexual risk orders in Northern Ireland, statutory authority for the National Driver Offender Retaining Scheme, and powers for the police to apply to the courts for an order to obtain information about the location of human remains outside of a criminal investigation to be included in the LCM. It is not agreed to the inclusion of the measures relating to the extradition of information from mobile devices to be included at this stage, but may return to the issue when the Code of Practice has been drafted and consulted on. The Home Office is also intending to table an amendment to the bill at the Commons stage to bring electronic money institutions and electronic payment institutions within the scope of the POCA account freezing and the powers in respect of the Northern Ireland to ensure that the law enforcement is able to quickly and efficiently freeze the proceeds of crime and the terrorist property, not just held in bank and building accounts, but also when in e-money and payment institution accounts. Members will recall that there was insufficient time to bring forward an LCM in respect of the Financial Services Bill to implement this provision in Northern Ireland, and the Ministers asked that the Home Secretary identify a suitable alternative legislative vehicle to do this. The Minister intends to lay the legislative consent motion or memorandum for police crime, sentencing and courts bill at the end of August for debate in September. And what we want to do is to seek the agreement of the members to refer the response from the Human Rights Commission to the Department for further response to highlight the issues. Agreed? Right. Okay. And if whether the members are content to note the response from the Department providing additional information and the updated position regarding the provisions to be covered in the LCM, or whether any further information or clarification is required, or whether they wish to submit any views or comments in advance of considering the legislative consent motion in September. Rachel?
Chair, thank you for that. I was reading through it, and there's so many issues that I just don't see answers to or full answers to, and maybe I'm just not understanding it properly. But the issues that we raised last time with regard to the consent motion and the Attorney General, codes of practice, it wasn't being addressed. The issues raised all capable of being addressed. Are they going to be addressed, or are they capable of being addressed? Because those are two different things for me. And within the human remains aspect, it said the department's response saying it hasn't engaged with the NIO or the Department of Justice Ireland, but it has brought the provision to their attention. So is it they haven't engaged, or has it that bringing the attention, no engagement? I'm just a bit confused of how you can not engage but also bring something to their attention. And also, if there has been no engagement and no views from either the Home Office, the NIO or the Department of Justice Ireland, how has the view been formed in the department that there's no impediment on their, on each organisation? So, did the department ask for a response or allow issues to be raised, especially if there hasn't been any engagement? So I'm just a bit confused about where that view has come from if there has been no engagement and no correspondence, because again it's not the same. In terms of the Northern Ireland human rights response as well, there's been a number of areas that have already been covered, which I would have concerns still about, without having further information from the department and a response to the Northern Ireland Human Rights Commission. I wouldn't be able to be of an opinion on the LCM until we had that.
Kristen?
Yes, I think, Rachel, what's happened is the Home Office who hasn't engaged with the NIO or Department of Justice Ireland, so the department has brought the provisions to the attention of both those departments, and what they've said is they've not made any comment and have not raised any issues, but we can go back and clarify that again. I'm not sure whether, given the questions you have, Rachel, whether it would be easier to have the officials back up to answer any further questions we have at the beginning of September, or whether we can write in the meantime and then, depending on the response.
Well, Rachel, if you want it, and I'm not asking you to do our homework, but those but really I am. What if you did? If you dropped a note into us, what we would do then is we would just forward that on to the department and then see what that response was before they lay the LCM in August, and then if we think we need to, we can bring them in September before that happens.
No, that's fine. And I have all these questions already written down.
Yeah, I knew
so
that was the case.
I just forward them on. I'll happily do your homework for you.
Okay, thank you. Appreciate that. Okay, if there's nothing else on that, then we'll move. Don't think there's any other member. Okay, thank you. Item 8 is the SR on the Parole Commissioners Amendment Rules, Northern Ireland 21. And that's at pages 282 to 307. At the meeting of the 19th of November in 2020, the committee agreed that it was content with a proposal for a statutory rule which is subject to negative resolution procedure to amend Rule 22 of the Parole Commissioners Northern Ireland Rules 2009. The amendment will introduce provisions which allow registered victims or other parties where it is considered to be in the public interest to receive summaries of parole decisions. At the meeting of the 10th of June in 2021, the committee noted an update from the Department on the proposed statutory rule, which indicated that following further consideration of the matter, it had removed the requirement on members of the public to justify receipt of a summary of reasons on public interest grounds. The adjustment recognises that the requirement was not aligned to the commitment to the principle of open justice, and the rule is now based on the presumption that the public interest test is met, save where the Commissioner does not consider on exemption grounds only that it is in the public interest to do so, i.e. the presumption will be in favour of the release of information. The Department also advised that it had delayed finalising the proposed statutory rule until now to take account of any relevant developments in 2 ongoing legal challenges. The committee agreed to request further information on what engagement the Department had undertaken with key stakeholders on the changes made since it had considered the proposal for the rule back in November 2020 and the views received, particularly from victim support, and whether it was content. The committee also requested clarification of when the outcome of the legal challenge is expected and, if necessary, what scope there is for review and amendment of the statutory rule. The Department has responded advising that it has engaged with representatives from the victims' organisation Schemes and Victim Support NI on the proposed change and in relation to the reviewing current systems and processes to ensure that victims are aware of their rights to request and receive a summary of reasons for the parole decisions. The Chief Parole Commissioner has also confirmed he is content with the change. The Department has also provided an update on the provision relating to the two legal challenges. The Department has also indicated that it will be bringing forward another proposed amendment in Rule 22 in a separate statutory rule. This amendment is needed to make it clear that the process to provide a summary of reasons can be undertaken by a single Commissioner, thus ensuring value for money in relation to the transactional costs. The Department will provide the SL1 to the Committee for consideration at its meeting on the 1st of July. The Examiner of Statutory Rules has no issue to raise with regards to the technical aspects of the rule. So just to ask members, are you content with the statutory rule in light of the additional information provided by the Department? Content? Great. Okay. So if the committee is content with the statutory rule, can I put the question? The Committee for Justice considered the statutory rule 2021-138, the Parole Commissioners Amendment Rules Northern Ireland 2021, and has no objection to the rule. Agreed? Agreed. Thank you. Agenda 9, the next steps for the MacLeod remedy for judicial and police pension schemes. And that information is at page 309 to 406 of the meeting pack for today. The Department has provided an update on the next steps to deliver the MacLeod remedy for the judicial and police pension schemes. Both schemes will require primary legislation, and the committee has already received information on the Finance Minister's proposal to extend the powers in the Public Service Pensions and Judicial Offices Bill at Westminster to Northern Ireland by way of a legislative consent motion. Committee has previously agreed that it was content with the Department of Justice proposals in respect of the judicial pensions reform and agreed in principle with the proposal to proceed by way of an LCM. The Police Pension Scheme requires corresponding secondary legislation to amend regulations to deliver the remedy and remove age discrimination, and the Department of Justice is responsible for bringing these forward. It is expected that the secondary legislation will be delivered in 2 phases to implement the prospective remedy by April 2022 and the retrospective remedy by October 2023. And this is just to ask members to note the next steps of the implementation of the MacLeod remedy for the Police Pension Scheme and Judicial Pension Scheme, unless there is any further information or clarification that we require. Okay, thank you. Item 10, the review of the hate crime legislation in Northern Ireland, the Department of Justice response to the recommendations, and that is at pages 408 to 538. And Judge Desmond Marion published his report on the review of hate crime legislation on the 1st of December 2020 and made 34 recommendations. The review considered whether the existing legislation represents the most effective approach for the justice system to deal with criminal conduct motivated by hate, malice, ill will or prejudice, including hate crime and abuse which takes place online. The Department has now provided its initial response to the report findings, the recommendations, and has indicated that none of the recommendations have been rejected at this stage. The Department has set out a dedicated hate crime branch to progress the work, and following further policy development, it will be in a position to publish a public consultation on proposals for hate crime legislation in Northern Ireland, which will inform a consolidated hate crime bill to be scheduled into the legislative programme for, you'll be glad to know, the next Assembly. The Department will keep the Committee informed of the key developments, including legislative time frame. And I saw you all have a bit of a moment there when you thought there's another piece of legislation, but there is another piece coming, I understand, and we'll maybe conclude with that before the end. And just to remind members that Judge Marion will be attending the committee on the 8th of July to discuss his report and the Department's response. So it's whether or not there are any other further information or clarification that we require in advance of Judge Marion's attendance on the 8th of July. Linda.
Thank you, Chair. Is it the Department's intention to carry out the public health consultation before?
Yes.
So
I think so. Is that right, Christine?
I'm not sure. We will.
Oh, we'll just clarify that. Yes.
We'll clarify that.
So the other periods, right? Sorry, there's bad feedback. I don't know if other people are getting it, but Annex A states that the recommendation on creating a definition of sectarianism considered as in conjunction with the report. So are they going to sit their hands and do nothing, or will they be working on it in the meantime? You know, because that would be a concern. I don't think they should be waiting on FICT. Given all of our experience, that could be a long wait. So I think
we missed the first part of that, Linda.
There's bad feedback, Chair. I don't know what.
Yeah, there's something has happened. Can you? I tell you what you do. If you just drop us.
Can you hear me now?
Yes, we can hear you now.
So it's just to ask the Department that the recommendations around creating a definition of sectarianism, they're saying that that will need to be considered in conjunction with FICT report. I don't think they should be sitting on their hands waiting on that. I would like to think that there will be work being carried out in the meantime. So just can we ask for confirmation from the Department that they will be working on this and not sitting waiting on the FICT report? That could be a substantial wait.
Yeah, okay. Well, we'll seek clarification from them on that. Anything else?
Thank you.
Rachel?
Thanks, Chair. It was just to pick up on what Linda had said there. It was just obviously I don't have any knowledge about what's going on with FICT, but it's been referenced quite a bit in the report. So it was along a similar lines in terms of waiting for that to be published. I know that that was due last year, but I don't know where that is. But do we have any idea about when FICT's going to be published? And also if there is a timeline for the department to work to for the next steps that are in that document. I was part of a group that recently met with the Minister as part of the APG and ethnic minorities on Tuesday morning, which was good to get an overview from the Minister. But in terms of just the department's work on next steps, mindful that we can't get hate crime legislation coming in this Assembly mandate, fully appreciate that it needs a standalone bill, but just to see if there are any timelines that the department are working to would be useful before that briefing with Judge Martin.
Okay, thank you. We will progress that. Thanks, Rachel. That concludes that. That brings us to item 11, which is the phase 2 of the review of the PSNI injury and duty. And that's at pages 540 to 562. And at the meeting on the 25th of February, the committee considered an update on how the Department of Justice was taking forward their recommendations in the Northern Ireland audit report in relation to the injury and duty scheme for police officers. The committee was also informed on the 27th of May that the Minister of Finance was launching a consultation on the Northern Ireland Civil Service Injury Benefit Scheme, which applies to prison staff. A phased approach is being adopted to addressing the recommendation of Phase 1, covering short-term action to mitigate offset issues, is now complete, and the Department has provided a summary of the next steps with indicative timings for Phase 2, which covers a thorough examination of the other issues in the report, and has also confirmed that it will accommodate the Northern Ireland Policing Board's request to incorporate a review of the ill health retirement process. The Department will brief the committee on any changes proposed to the current scheme and seek the committee's approval to proceed to a stakeholder consultation in due course. And it's just to note the update provided to us and whether or not there's any other information that we require. I don't see any members indicating. Linda?
Just a very quick point, Chair. I don't want to keep you from getting something deep before the LCJ comes in. If we could just forward that on to the Policing Board, just to ensure that they're content that what's being said there, it does look 100% to me, but just to ensure that what's being said there, they're content. That is, in fact, the case.
Yep. Okay. Agreed to do that. Yes, that's fine. Item 12, review of non-fatal strangulation legislation, which is the proposed consultation, which is on pages 564 to 606. And the Department is proposing to undertake a public consultation on the review of non-fatal strangulation legislation and has provided a copy of the draft consultation document. Consultation focuses on the need or otherwise to legislate on this discrete issue and seeks views on a number of options. And it's just to seek the views of members on whether they are content to note the proposed consultation and consider the matter further when the results of the proposed way forward are available, or whether they wish to submit any views or comment at this stage or require any further information. Linda.
Sorry, two very quick questions on this one too, Chair. Just if we can ask if the reference group have had sight of the actual consultation. I mean, it looks like they've had a good reference group in place in developing it, but have they actually had sight of it and said that's a good consultation? And when do they intend to consult?
Yes.
That's it.
Yeah, okay. Yeah, get a time frame. Yeah. Okay. Thank you. And then item 13 is the Department of Justice June monitoring round return, and that's at pages 608 to 660. Officials attended a meeting on the 3rd of June to outline the Department's June monitoring round position and the 2021 provisional outturn, and the Department has now provided a copy of its June monitoring round return that they submitted to the Department of Finance. The response from the Department to the questions raised by the committee following the oral evidence session is due by the 1st of July for next meeting. So the Department has also responded to the committee's request for further information on the areas included in the Cross Justice Recovery Bid, which was part of the recent 2021-22 public expenditure COVID-19 exercise, and the Department's accruing resources of almost 52 million for 2020-2021. Just to note the correspondence and whether there's any further queries or information that we require from the Department. Okay, noted. Thank you. And that brings us to a break until 2 o'clock. So those on Starleaf can now go boil the kettle, and we will now go into the rotunda, those of us that are in the Senate, and enjoy sandwiches provided by the Assembly. Not that we would ever want to laud it over you, but that's what we're going to do anyway. But thank you, really do appreciate your help in getting us through that, and we'll see you all been well at 2 o'clock. Thank you.
Thank you.
Senate Chamber, programme signed.
Your help, and I'm sure you've enjoyed a cup of tea or whatever refreshments you had in your offices or wherever it is you are. So we're going to resume, and welcome to this afternoon session. And that brings us to the last meeting that Sir Declan will come in his role to the committee. And of course we're delighted to have the Right Honourable Sir Declan Morgan, the Lord Chief Justice for Northern Ireland, in attendance with us today. And I want to just at the outset say, Sir Declan, a word of appreciation and thanks to you for your years of public service, for your contribution. I believe I'm right in saying that you were the first Lord Chief Justice to come before a committee of the Assembly, and I think your bravery and your fortitude in relation to that is much appreciated. But thank you for your openness, and obviously the judiciary is something which people have varying degrees of opinion of, but I think that you have taken very bold steps in years past to try and demystify some of the issues around the judiciary and the judicial process, and that has been very much appreciated. We also welcome Mandy Kilpatrick, the Principal Private Secretary to the Lord Chief Justice. You're very welcome. And so, Sir Declan, without any further ado, we're just going to allow you the opportunity to say a few words to us, and then members, I have no doubt, will have some parting questions to ask on this occasion. Thank you.
Well, thank you very much, Mr. Chairman. I'm feeling in very good humour as a result of your generous remarks. Whether the humour remains by the end of the evening, we'll just have to see. I provided you with a bullet point, as it were, paper of what I'm going to cover, which I hope is helpful in terms of following it. I think one of the biggest lessons and one of the biggest positive outcomes that we've had as a result of the pandemic has been the collaborative working that has occurred between the different elements of the justice system as a result of the pandemic, and the need to pull together to understand each other's difficulties and what each can contribute to the way in which we can make the system of the administration of justice better in Northern Ireland. At the start, we reduced down to 5 hubs, and in those hubs, effectively through until about the beginning of May 2020, we were only able to do emergency business. But we've now got to the stage where the vast majority of magistrates' courts are now open. We've had additional magistrates' court sittings implemented back in August 2020. They obviously continue throughout the year, and there has been a fantastic effort by the district judges in that tier to attack the backlog, and although it's not by any means completed, certainly the presiding district judges indicated to me that by the end of this year the issues connected with the backlog will have been dealt with. and the department has looked at the figures as well and is of the same view. So that is, I think, very encouraging. The story is somewhat different in the Crown Courts. In the Crown Courts, we weren't able to get back to work until August 2000, and then we had a total of 8 courts available to us. Now, when we, in pre-COVID times, we would normally have had 13 Crown Court sitting, 1 High Court and 12 County Court or Crown Court judges. 8 meant that although we were able to do some of the work, we certainly were doing that in a context where the backlog was increasing rather than decreasing. And that really remained the case until we got additional courts, and we now are back up to 13 courts available to us from about the end of April 2021. And I would anticipate from 2021 on through until the end of September 2021 that we will see the Crown Court broadly holding its own against a background of a steady increase over the norm in terms of cases coming forward from the Magistrates' Court. As the backlog moves through the Magistrates' Court from the PPS, then yet more cases go through, and the rate of receipts at the moment is actually higher than the norm that there's been. We have, and again, the department has agreed that the number of courts available to us will increase to 15 from October 2021, and that's the stage at which we begin to see the backlog decreasing, where we will be disposing of more than is actually received. And I'm anxious to ensure that we attack that as quickly as we can, because of the related matter of committal reform coming down the track, as it were, possibly as early as late 2022. We were fortunate in one sense going into the COVID period that we didn't have the backlog that England and Wales had. Mr Justice McFarlane, as he now is, was the Recorder of Belfast, and he did a fantastic job of managing the Crown Court lists, and they were really in the best shape that they'd been for some years. The position at the moment is that we probably have pretty close to 50% more cases waiting for hearing than we had at the 1st of April 2020. So that gives a sense of the backlog, but the numbers we're talking about are 583 on the 1st of April 2020, and we're probably now up to something close to 900 waiting to go. We've had some experience of what to do about a backlog, because some of you may even be old enough to remember that there was a difficulty over legal aid funding in the justice system. And for a period of about 10 months, from May 2015 to February 2016, no Crown Court cases were moved. Now, we dealt with that backlog, but we've learnt from it as well. One of the pieces of learning was that there was a tendency to take the low-lying fruit and take the easy cases in order to get the figures down and make it start to look as though it was sorting the problem out. But beneath all of that, there was a tail of particularly sexual offence cases which were not dealt with because they were more likely to be contests and were more complicated to bring forward. And we have learnt from that, and we have been very anxious to recognise the risks of attrition in that area, so that we now prioritise the cases on the basis of sex offence cases, custody cases and children's cases as being the three areas where we need to be sure that we're listing as much as we can in the circumstances, and those are their priorities. And all of that is designed, of course, to maintain confidence in the justice system. On the civil and family side, actually which, as it happens, the senior family judge was Mrs. Justice Keegan, who will be my successor. But the family side has actually done exceptionally well in terms of ensuring that family business was dealt with. There were always some cases that had to be put off for a period and that required some innovation in terms of dealing with them. But there are very significant signs of recovery there, and a pattern which shows that broadly family business was being disposed of pretty close to at the same level as it was coming in. We've also, I think, been fortunate on the civil side with the personnel who have been involved, Mr. Justice Horner on the commercial side, Madam Justice McBride in Chancery, and Mr. Justice McAlinden in the High Court. And I mean, they also have done an excellent job of ensuring that their business is recovering, and we now have these lists back into shape. And certainly for any significant cases that need to be progressed, they will be progressed. Prime example of that might be that gentle dispute between Messrs Frampton and McGuigan, which we managed to get on in September of 2020. And clearly it was fought to a draw because they decided to pull stumps and indicate that they settled the case at one stage. Another thing that we've obviously learned from the system is that we really need to think hard about modernisation. We need to think about innovative and creative ways of dealing with work. Not everything has to come through these traditional streams of getting into court, whether it's through the county court or through the High Court. There are all sorts of ideas out there about the way in which we can use online access and online dispute resolution in order to ensure that we target the cases at an early stage and allocate them to the right place. In other words, a kind of triage system as they come in. So the cases that can be sent towards resolution, possibly by mediation, can be identified at an early stage. The cases that will require the full court procedures to be applied to them will also be identified that way, and that should assist in encouraging these cases to be moved through more quickly for the advantage of the parties. We are doing still a reasonable amount of work remotely, and I think it's clear that we will continue to do elements of the work that we do remotely. It's extremely advantageous for the practitioners who are able to basically do their work from their desks as they sit. And there's no reason at all why we should be adding in cost to the system by making people come down to a court for a review hearing, which can be perfectly adequately done via the present system. I have agreed a vision statement with the Minister and the Court Service in relation to modernisation, and also established a Judicial Digitisation Steering Group, which is led by Mr Justice Horner and Mr Justice Huddleston. And we have been looking through that group at developing a strategy for digital courts that will actually identify what we think is necessary in order to introduce a modernisation programme. I mean, this is going to cost money. There's no point in pretending that it isn't, and that means it's going to take time because there's no magic money tree, and nobody is going to be offering significant sums of money to make all of this happen. But it does seem to me that it is important that we have a strategic vision, as it were, of where we're going, so that at least when we're making plans about the way in which we do things, whether it's modernisation for the PPS or for the PSNI or for some of those other agencies which are participating in civil work, that we make sure that we're talking to each other and we have a common view about where we're going and how we're going to get there. And I think that will take time. I mean, it is going to require a degree of consultation. It is going to require leadership, and I think we need to think, we will need to continue the engagement that we've had with the other areas of the justice system to make sure that that is going to be sensible, and we'll also need to talk to the department about the financing of that. And I suspect that somebody will be sitting here at some stage in the Justice Committee explaining what the judicial view is about how all of that might be accomplished. We have benefited unquestionably from COVID legislation in terms of the way in which we are able to work. The remote hearings give us a more effective way of dealing with certain situations, such as the first remand hearing from the police station, where the accused can be brought in remotely. It allows for witnesses to give evidence remotely, and that is of particular benefit to expert witnesses. In the criminal field, we wouldn't have been able to do that, but we have been doing expert witnesses in the family field for years. And we have hearings which have to start at 8 in the morning because we have to accommodate somebody in Australia, or perhaps somebody in America, where you start in the afternoon rather than the start of the day and sit through. I'm glad to see that the committal reform bill is making its way through. I think this has the opportunity to be a game changer in terms of speeding up justice. I think if it's going to work, once again, we'll all have to talk to each other. We need to make sure that the PSNI, the PPS, the courts, the defence solicitors are all understand exactly how this happens. We'll need strong case management to ensure that when cases come into the Crown Court, as they will, that they're not being reviewed endlessly for periods of years. These cases need to be directed upon at an early stage. People need to engage with them to understand what it is they need, and the judge needs to take control of identifying what the issues are, requiring the parties to cooperate in relation to that, and then getting on with getting the cases through for hearing. There have been, I think, some concerns expressed about what the effect will be of taking all the indictable cases over to the Crown Court immediately rather than leaving them in the Magistrates' Court. I think the point is that the Crown Court is where they should be, because the Crown Court judges have the expertise and experience of how to manage these cases, and therefore will be able to get to grips with preparing them in the way that they require. Our present legislative arrangements actually don't give the Magistrates' Court the power to do any of that. The only task for the magistrate is whether or not the case is ready to be sent forward. So the magistrate is not involved in working out, do we need experts? Can we agree some of the evidence? Are the charges right? Should we be thinking about something else? That's not what their task is. But I think the Magistrates' Court has a role to play in terms of the overall criminal justice system, in that at the moment its general jurisdiction is in or about 12 months in terms of sentencing powers. In some instances, like criminal damage, it is 2 years, in others it's 6 months. But it seems to me that we have, unlike England and Wales, a professional magistracy, people who are experienced lawyers, who are well trained, who will continue to be trained through the Judicial Studies Board. And I think these people are entirely capable of dealing with cases with a greater sentencing liability. My suggestion has been that any case the magistrate should be entitled to impose in respect of any indictable or either way case where it's appropriate sentences of up to 5 years. Now, that doesn't mean that anybody would be forced to have their case heard in the Magistrates' Court, because it would be, you would have the either way approach. In other words, there would have to be an election by the accused, and the accused would be perfectly entitled to elect to go to the Crown Court if that's what the accused wanted to do. But I think you would find that there are a lot of cases, drugs possession cases, possession with intent cases, where there are sentences of less than 5 years that are appropriate, but they're outside the present range at the moment, and those cases would be knocked out at considerable saving to the PSNI in terms of the time they would take to prepare the file, and similarly considerable easing for the PPS as well. And I would hope that at some stage, obviously not in this mandate but beyond, that some serious consideration could be given to that. I'm also glad to hear that progress seems to be moving in terms of the Justice Bill in connection with the recommendations of Sir John Gillen in his review of serious sexual offences. I mean, John's report came in 2017, which was perhaps not an auspicious time in terms of looking to the Home Legislature to get things done, but his report is, as always, a comprehensive analysis as a result of careful consultation and a discussion with the affected parties. And I think that the proposals within the Justice Bill which are sought to be brought forward are bound to be of considerable support to the victims of sexual offences, and will contribute to all of us trying to ensure that we don't have attrition in relation to those offences, whatever else happens. And I think I hope that within this mandate you may be able to achieve that outcome, and I think that will be very welcome indeed. We have taken on board John's recommendations in terms of a practice direction looking at vulnerable witnesses. Thanks to the efforts of Her Honour Judge Smith, we have a pilot now involving children under the age of 13 who are involved in cases of sexual abuse or sexual offences. And the objective there is to see if these cases can actually be disposed of within a 6-month period. And considerable work has been done by everybody, the PPS and the PSNI, in order to make that happen. It's again the product of joined-up working, which the judge led, and the outcome, I think, has been again of great benefit, albeit it's a small number of cases, but it points the direction that joined-up collaborative working can actually move these things along quite considerably. Similarly, in civil and family justice, we have, again, major reports from Sir John Gillen, and I had asked him, as he was coming towards the end of his time at the Court of Appeal, to take this on. As I've explained to some others, way back in the early 1970s, Lord McDermott sat down to do a report in relation to the administration of justice in Northern Ireland, and that led to the Judicature Northern Ireland Act in 1978. And it seems to me that the remarkable work that John has done in terms of civil and family justice should form the bedrock, almost like the instructions to the drafter, as it were, in relation to an Access to Justice Act, which I hope will come through within the next mandate. There's nothing controversial about it. I mean, he anticipated some of the issues around digitalisation that we've had, and if anything, we probably would be trying to go a little bit further this time. But I'm enormously grateful to him, as indeed are all my colleagues, for the work that he has done in bringing those reports through. Everybody's entitled to have a bee in their bonnet about something or other, and I suppose my bee is in relation to whether or not there should be a non-ministerial department which deals with the way in which judicial support services are provided in Northern Ireland. As I'm sure you know, in Scotland and the Republic of Ireland, there are court service boards which are judicially led, which have the functions of looking at the support services that are available to the judges in connection with the work that they do, so that the court clerks, people who put the files together, where the information is got, where the summonses are issued, etc., and also for the court estate. Now, this is where I'm probably going to fall out with people, and I hope I don't do that in too bad a way, but The reason actually behind this, at least in part, and I've spoken to both Susan Denham, who was the Irish Chief Justice, and to Brian Gill when he was Chief Justice in Scotland, and I've also discussed it with Lord Carloway and with Arthur Hamilton, who was the Lord President in Scotland when I took up my post. The problem is, you know, we all want to have a court estate which provides for members of the public who are coming into 21st century services and facilities, and enables them to see the courts as a modern, effective, friendly, in some cases child-friendly venue for things that need to be carried out, whether in the civil, family or criminal side. But I mean, we all know that it's hugely difficult. It's exactly the same as in health. It's hugely difficult to implement that, because it will mean in some cases that courts may have to close, or the range of work that they do may have to change, and that there would be investment in other courts, and that inevitably arouses considerable local anxiety. And in fact, it's not just among members of the public. It can arise considerable local anxiety among judges as well, because I remember when we eventually got round to closing Larne Court, that the district judge made a scathing statement about in his last hearing about the fact that this wonderful facility was being removed from the people of Larne. So, I mean, I understand the issues all right. And the net result of this is this, that I mean, if you look at what we've actually managed to deal with over the last number of years, we've lost the Crumlin Road Courthouse, which was a magnificent building. The reason we had to move out of it was that pieces of plaster were falling on people, and we were concerned that people were going to get hurt. We've lost Larne. We've lost Bangor, which was another iconic building, but again, the pieces of plaster were about to fall off the edge of it, although I noticed that it has now been provided, I think, to a community group who hopefully will make some good use of it. But we in 2006, I remember well, it was 2 years after I was appointed as a judge, the then head of court service, David Lavery, commissioned a wonderful appraisal of what the court estate should be. And I remember myself and the late Brian Kerr and a number of others went down to see this wonderful way in which the court services were going to be delivered. And it had wonderful pictures in it, and you know, it was brilliantly done. And we all went down to look at it, and we all put it away, and we never saw it again. Nobody ever saw it again. So that's 2006. Move on to about 2015-16, and you'll remember that there were a number of courthouses which were put on ice, of which the most iconic is probably the Town Hall Street, right beside the courts, which is still closed at the moment, but waiting there to be revived. We had Ballymena closed for a while, but that's reopened again. There was a proposal to close Limavady and Strabane, Marifelt, and one or two others. But local objection intervened, and oddly enough, what happened was that nothing happened in relation to that. And that's exactly what happened in Scotland, and it's exactly what happened in the Republic. That if you like, the political process is not well attuned to this type of reorganisation. So what happened was, in each case, they sent this off to people who were commissioned to do the job. They had to do all the consulting and come up with the plans and then implement them. And they were subject to judicial review in relation to whether they got it right or whether they got it wrong. But it was outside the hands of the politicians in both Scotland and the Republic of Ireland. And it seems to me that the high likelihood is that if we leave things the way they are, in 2026 there will be another glossy produced, but nothing will have changed, and the court system will still not be appropriate for their users. So that's my big ask, that serious consideration is given to whether the structures that have worked apparently so well in Scotland and the Republic of Ireland, which have virtually no differences between them, are relatively small jurisdictions like our own, be given serious consideration by the political classes in this jurisdiction. So I hope you haven't been too upset, Mr. Chairman, by the bee in the bonnet, but no. I assure you that all the bees are now deceased.
No, I think, Sir Declan, it is an opportunity for you as well to be able to, in this forum, to give your commentary, and that commentary, I think, is accepted in the way that it is presented, and you have certainly given us food for thought on a number of issues. As opposed to try and tease some of these out, and can I just remind members if they would either indicate by, now the hands are all starting to go up now, so I have a screen in front of me here, so I'll try and manage this as expeditiously as I can. In terms of this, the modernisation piece, and obviously the committal reform bill and post-COVID, so if you take all of those as component parts, do you see there being a challenge, particularly in relation to defence, in how the system, because all the parts of the judicial process have to move together, and you reminded us of a time when there was the walkout and there was a strike, which created its own challenges. But in terms of trying to get to a better place, which is a better place ultimately for those who have to use the judicial process, do you think that the COVID experience and the issue of the remote hearings are those elements that could remain, and that would add to and be complementary in terms of the modernisation that is needed to help in the delivery of justice?
Yeah. I mean, I have absolutely no doubt that there are elements of the COVID arrangements, as it were, that will continue in one form or another. A lot of the case management work that is done, it seems to me, will be capable of being dealt with in a remote way, but it will require legislation in the criminal field. I mean, if the COVID regulations were to fall, or the arrangements under the Coronavirus Act were to fall, we would not be able to do remote hearings in the way that we're able to do them at the moment. So it is important for us, and I think this will be true right through the jurisdictions in the United Kingdom. It is important for us that those regulations remain in place, and I know that my counterpart in London, Ian Burnett, has made the same point. So I think there's no doubt that is going to happen. I think the point about the defence moving along with us is a point well made, but it's again an indication of the fact that these things happen because everybody is consulted. And I think the important thing is to ensure that you get the defence who see what you're trying to do and can understand the benefits of it. So we've seen that happening, for instance, in just pre-COVID, we had set up a range of Crown Court progression committees, which involved the judges, the practitioners, prosecution and defence. And there was a great deal of common understanding of what we were going to do and compliance in relation to the way in which, as a group, it was felt that things could properly be done. So I don't see any issues surrounding bringing the defence on board in relation to the way in which we can do this more effectively. It's been done elsewhere, and our lawyers are very good lawyers, but they're perfectly able and willing, I think, to engage in an effective justice system.
You did mention, and I think that it's a valid observation to make in relation to confidence in the judiciary. And obviously that is an issue that we have had to deal with across confidence in this place where we sit today, confidence in policing, confidence in the judiciary and so on. And we cannot make reference to specific cases. But obviously there have been in recent days very vocal commentary made about sentencing and the leniency of sentencing. In terms of that reform piece and the work that will be done, the committal reform and so on, do you believe, having come to this point in your professional career, looking back over those, I think if I'm right, is it 45 years since you first came to the bar? If I'm right, or Wikipedia is right, it was 1976.
Yeah.
Do you believe, Sir Declan, that the judiciary does get it when they see the public reaction, and not just in the last few days, but over a period of time, and there have been numerous cases, that given the nature of whatever the particular offence is, and in some cases where the offence was particularly harrowing, that giving a lenient sentence, that, and I have no statistics for this, when it may subsequently be appealed, a higher tariff is granted. Has the judiciary moved in that space that gives or could lead to greater confidence that if someone is before the court for a very horrendous, and you take the work of Sir Joe Gillen and his work and the horrendous things that go on sadly in society today, people do look for those who are the perpetrators to actually feel the wrath of the law, as well as being given the rights that they do in a democracy such as we have.
I agree that it's important that there's public confidence in the way in which judges sentence offenders. I also I think it is helpful that there is an opportunity to review any sentence that appears to be unduly lenient, and I had indicated to the present minister's predecessor that a review of unduly lenient sentences and an expansion of the cases that could be considered in that seemed to me to be something that was perfectly proper and legitimate for the legislature to do if they considered that it was appropriate. We have, on occasion where it seemed to us appropriate, we have significantly increased sentences in areas, for instance, most recently where there had been a campaign of sexual abuse of a child, and where we took the view that a sentence should be increased by, I think it was somewhere in or about 7 or 8 years on top of the sentence that had been imposed. And I think there's no doubt that stiff sentences are necessary in relation to certain types of cases. We have guidelines which talk about, for instance, in serious offences of violence, about the importance of recognising terrorist involvement in cases of that sort. And for myself, I mean, I'm sort of beginning to wonder whether we should change that rubric somewhat and recognise that the same approach is appropriate in relation to organised criminality, as distinct from just indicating it as a pure, as it were, terrorism matter, because I think there's increasing evidence of organised criminality activity which may or may not have originated with those who might have been involved in some way or other with something or other, but that there are groups now who independently are organising themselves in a criminal fashion, which it seems to me would justify virtually the identical approach to the types of cases that we're talking about. That's an area where I think, as a matter of sentencing policy, I could see that shift, as it were, to recognition of the importance of examining organised criminality.
Thank you. We're going to go to members, so I will try and do this as fairly as I can on the basis of how I saw hands go up. So, Sinead, we'll go to you first. Thank you.
Thank you, Chair, and apologies for missing the earlier session. And I want to thank and welcome the Lord Chief Justice for being here with us today, and also for the very intense and thorough briefing, not just here today, but the earlier paper which we caught sight of. I would be eager to know, and you made the point very well, Sir Declan, about the justice system and the committal reform piece being a piece that could speed up justice, I suppose, and putting it in the right place. But I have a niggling concern, and I wonder, could you speak to it, in terms of then the volume of work that would move? Do you have any fear that there could be, in the stretch or the objective of trying to speed up justice, that there is the potential for achieving best evidence not actually come into play? And a second point I'd like to raise with you, and no doubt in your many years, as the Chair has highlighted, you will have watched many reviews come and go, and some being implemented and others disappearing, unfortunately, without enough regard. I would like to know what your personal view is in terms of the speed of action that has been happening or not happening around the Gillen recommendations.
Well, if I can just deal with the last point first. I mean, I'm disappointed we haven't been able to implement Gillen, all the aspects of Gillen, as quickly as we could. But my focus, I have to say, is more on getting those recommendations that remain outstanding done, rather than looking back to re-examine and try to apportion any kind of fault or blame in relation to the things that haven't happened. Turning to the first part of the question, Sinead, if I may, I don't think that the committal reform should impact adversely in the way that you've described. I think there's, and it was identified and recognised by John in his reports, I think the facilities that we offer for those who are victims, children, those who have been subject to sexual offences, needed the review that John provided. And I think that we're moving towards a place now where achieving best evidence is a feature which is going to move independently and will involve, I think, within a relatively short time, the preparation of cross-examination as well, at the more or less at the time at which the offence is being committed. In other words, in circumstances where the victim can actually remember clearly what has happened, rather than leaving it until some trial that might be 9 months, 12 months, 18 months down the road. So I think that that presents its own challenges quite independently of committal reform. It means that both the PSNI and the PPS will have to work hard at questions of disclosure, because you don't want a situation to arise where you have an early cross-examination of a victim, and then somebody turns up with a raft of disclosure documents and says, oh dear, I didn't get a chance to cross-examine in relation to those. Now, I did see the Lord Chancellor, Robert Buckland, indicated last week that there was some mechanism now whereby phones could be held by police for less than 24 hours, and the material in relation to them would be downloaded in some way within that period, and the phone returned. And I would hope that that is an indicator that particularly for that type of evidence, which has become so prevalent in these types of cases, that two things will happen. One, that the phones will be triaged quickly, but secondly, that the disclosure process recognises that there is privacy associated with items on the phone, and it doesn't mean that you just send the whole lot, as it were, a person's entire private life off to the judicial system because they have been a victim. I mean, that would be, I think, the most extraordinary outcome if somebody found that all of their privacy was invaded because they had been a victim, because in a sense that is re-victimising that person. So it seems to me that that independent work, no matter which way you look at it, whether you're committal reform or not, that's something that we really have to make sure happens. And I'm hoping that committal reform will be a factor in encouraging that to happen.
Thank you. So Declan, Chair, if I just may make one more point, I absolutely agree, and I think a lot of the legislation that's coming in front of us, it's increasingly the case where we're looking at the online world and technology, and I know the PSNI had made known to us the difficulties in terms of the resourcing for triage, and no doubt that will improve, albeit that it's slightly behind the technology itself being used. But if I could just take the opportunity, Sir Declan, to thank you and to wish you well, and to let you know that I did hear the bee in your bonnet, and that was a question I'd intended to put to you, if there was something that in your service that you particularly felt needed to be aired today, and I appreciate that you've done that, so thank you. Thank you, Chair.
Thank you.
Thank you, Sinead. Robin.
Thank you, Chair, and can I join with you in your thanks to Sir Declan and indeed to wish him well, as Sinead has done, for the future. Also, thank you for the written information, but indeed your wide-ranging remarks at the beginning. I do think it's important that we all should have a bee in our bonnet about something. I think that's an important part of life. I wonder, Sir Declan, you'd used a number of words: modernisation, innovation, strategic vision, and so on. And a very modern case that came up in Northern Ireland, and indeed made, well, certainly across the Western world, made world headlines, and that was the case of the Asher's Bakery. And I suspect that as our society moves, that there will be future cases of a similar nature. But indeed, for the cost of a cake, which was probably around £30 or £35, a high-profile case went through the courts of Northern Ireland, and at each stage, the young couple who owned the business, obviously under stress, not only personal stress themselves, but indeed stress for the potential future of their business, ended up costing hundreds and hundreds of thousands of pounds in legal fees on both sides. For the Equality Commission, if I remember right, something like 250,000, and certainly something a couple of 100,000 for the Asher's folk in legal fees. And yet, when it went to the Supreme Court, and Supreme Court sitting in Belfast, there was a unanimous decision in favour of Asher's. I do think we are likely to face future cases of this nature. Would you comment on that case in particular?
Well, I'm not going to comment on the case, but I'm going to comment on the principle. You're quite right
Fair point.
That litigation can be extremely expensive, and in fact it can be so expensive sometimes that there is a risk that people may not be able to afford to justify and sustain their rights. And I think that is a real concern for any system if you've reached the stage where people who have rights find that they are unable to do so other than at the peril of enormous financial cost, which either they can't afford or which would be catastrophic in terms of them and their family. So that is a concern, and I'm not sure what the answer to it is. I mean, I know that to some extent in cases of this sort that there's now a bigger emphasis on things like crowdfunding, which can actually manage to generate support from the wider community, where you have a right of that sort in relation to personal freedom and religious belief coming into play. It may be that we need to think about a more organised way of dealing with that, so that people who are facing this sort of case that goes to the Supreme Court are in a position to deal with it. And I think as well as that it probably in this area we've had more cases going to the Supreme Court, that touch in this type of territory. For instance, there was the case involving the owners of the boarding house who were faced with a same-sex couple who were seeking to avail of their facilities, and that ended up in the Supreme Court as well. And to some extent, the Supreme Court is there to give us clarity as to where the line is to be drawn as to what is protected within the context of the legislation, i.e. the Human Rights Act, and how any challenges apparent challenges as between the rights of different people are to be resolved in terms of whether one or other is discriminating against the other. I think that one of the things that I would say about that is that the court, I think it helps if the court is clear about what the position is. In other words, any ambiguity that is left in relation to this is simply an invitation for these matters to be raised again as issues. If we take this issue of the cake, there was actually quite a body of American jurisprudence. Some of it went one way and some of it went the other way. I mean, that would be a very unsatisfactory situation in which to find oneself. There were differences of view about what you had to establish for discrimination, whether or not discrimination in terms of effect as distinct from in terms of action was capable of being sustained. And there was certainly some European Union authority which pointed in that direction. But I agree with the general point that, first of all, it is important, particularly in sensitive matters of this kind within this jurisdiction, that there is a methodology of those who are affected by this having a means of vindication which should cause them the least stress possible in terms of their lives and their families. And I don't think that was achieved in the Ashers case, because the strain on that family must have been extremely difficult indeed. I certainly would want to do anything that I could to ensure that, where there's a similar situation of establishing rights, that we try to manage that in a way which causes the least stress and least hurt to those who are involved.
Thank you, Sir Declan. I have no doubt that there are going to be other cases of a similar nature as we move along in society. And the point I think about Ashers were in the, I suspect that the Ashers family must at times have been saying, we just settle here. And they were fortunate that they had Christian Institute who came in to provide them with support. But there must be many, many cases where the money is not available and folk do decide, I just can't afford it. So I take it on the chin and move on, even though I feel strongly that all the steps I took were honourable steps.
Okay. Any other question, Robin?
Thank you.
No. Okay. Thank
no,
you.
That's fine. Thank you, Chair.
Thank you, Linda, Vice Chair.
Thank you, Chair. Can you hear me okay?
Yes.
Thank you, and thank you to the Lord Justice for coming to the committee today. And I'd like to echo the Chair's comments in terms of thanking you for all the work you have done, and obviously wishing you the very best in the future. And I hope you have a long and happy retirement and get to enjoy it.
Hear, hear.
And again, thank you for coming to the committee today. I'm sure, hopefully, I would like to think that your successor will do likewise, and I've no doubt probably will follow in your footsteps, and will hopefully get to meet with Justice Kagan, or the Lord Chief Justice Kagan, as she will be then our Lady Chief Justice, as whenever she takes up her role. But just I have some questions of my own, but I just want to pick up on what you talked about in relation to the court estate, and I suppose that reluctance to give up buildings, and it's something that we face in relation to hospitals and many other types of buildings, that nervousness around losing a particular building in a particular area. And I'm probably conscious that people are, and I think health is probably going to lead on this, and it may have a knock-on effect, and that will be, for me, a positive thing. But people are coming more to the realisation that what matters is services and meeting the needs of the people who require those services. So the people who have to use the court for whatever reason, I suppose I could share a slide into it, and I had to use it. But for tribunals and supporting people and representing people in tribunals, and a lot more of those now happen in Dungannon Court here locally. And I mean, we're lucky in that Dungannon is a fairly modern courthouse, but obviously there are other courthouses which aren't. And many people, I'm thinking specifically of the victims and survivors of HIA, and during the Hart inquiry they were taken to a courthouse which a number of them have related to me that it felt like they were back in another institution, because that's what that building reminded them of. So I do think we have to have buildings, and you know, what we provide needs to meet the needs of those who we serve. So I do think that it is a conversation that we have to have and be honest about, and not you know, politic around these issues. I think it's important that we do look at what exactly do we have to do to meet the needs of those that we serve. So it's a bugbear of yours, but I'm certainly an open ear on the issue, and I believe that others would too.
Thank you.
That's just by way of a comment on that issue. Can I just ask you an analysis of the PPS last week? Chair, I'm just going to say there's bad feedback. I don't know whether maybe others aren't muted, so if there's maybe a way of...
Yeah, we're okay. We can still hear you, Linda. Okay, it's still okay.
You can hear me.
Yeah. Go ahead.
Okay. So I asked this of the PPS last week, but in relation to the proposed legislation that the British government are talking about bringing forward around the statute of limitations for state forces, have the NIO had any engagement with your office? Because obviously there will be implications for the judicial system and for justice as a whole. So I'm just wondering, have they had any engagement with your staff?
None other than that when they publish various suggestions been over the last number of months, anything that they've published has generally come through to my office. But I haven't had any discussions. I have had discussions with the Permanent Secretary about judicial security, and I have had discussions about with both the Permanent Secretary and with the Irish Secretariat in Belfast in relation to the general, as it were, scheme of how legacy should be addressed. I was asked by both to speak to them, and was happy to do that. But I haven't had any discussions beyond that, no.
Okay, thank you. I appreciate that. You talked earlier just in relation to the Gillen review, and I may be premature in asking that question because I know that this pilot scheme has only been launched 3 months, but the free legal advice for victims of sexual offences, I'm just wondering, are there any early indications on how the scheme is operating? And I acknowledge that it's very young, and if there aren't any indications really at this time, I totally understand.
Yeah, no, I don't think, Linda, that certainly there's been nothing fed back to me yet about exactly how that's working. I mean, I agree with you that it is early days, and I would expect, by September, October, that we should be beginning to see something.
Okay, I appreciate that. Thank you. And I'm just wondering then, can you give an update on the work to implement the recommendations in relation to tackling the jury rape myths?
Well, I mean, I think that we have had, shortly after John's report, back in 2018, I think it was, we put together a number of Judicial Studies Board training sessions in order to deal with this. Now, as you'll know, there's actually quite a debate going on at the moment about this. Cheryl Thomas, Professor Cheryl Thomas from UCL, is the person who has been carrying out this jury work now for a number of years. And in her latest writings, she has broadly come to the view that the notion of jury myths is itself a myth, and maintains that, in fact, jurors don't make decisions on the basis of a misunderstanding of what consent means, and other similar matters about ways in which victims are disadvantaged. But in our case, I mean, we have continued to emphasise the need to make clear to jurors exactly what consent does mean in these types of cases, to deal with any issues that may arise, and prevent any evidence which is purely prejudicial and has no relevant value being introduced into cases. And I think, although Cheryl may be of a firm view that jury myths are not are in fact a myth, I think we will continue to give directions which are based on the proposition that they might be, and therefore our directions to the jury should ensure that there is clarity about exactly how they should go about their task.
I appreciate that, thank you. And I think that probably we talked in the earlier presentation around child sexual exploitation, that a discourse around the issues and a positive discourse and a in a good and meaningful way would be a good thing. And I think that is no different in relation to this issue, that a positive discourse and just making people understand that somebody's reputation or what they were or don't wear is irrelevant whenever it comes to the issue of consent. So I think that it's important for the rest of society to have a positive and good discourse around it as well. We have Judge Marnan coming to us next week, I think. No, 2 weeks.
Yes,
The time slipping by that quickly, I'm not sure when, but just the recommendation around introducing new protected characteristic groups, including age, gender and gender identity, including transgender. Do you have a view on that, Mr. Declan?
Well, I mean, the introduction of that is a legislative policy matter for the legislature. I know that there is a practical element in relation to these cases, and I think it probably involves more culture than anything else, because it has always been the case that certain types of offence motivated in a particular way have by statute been identified as aggravating factors which should lead to a stiffer sentence. But there's also evidence that in a lot of cases, although people might plead guilty to the assault, that they will not plead guilty to the assault with the aggravating factor, and that a lot of victims and prosecutors, therefore, as a result of that, a lot of victims were unwilling to see the case contested, and prosecutors were unable to pursue that matter through. Now, I think there will have to be a culture change so that we make sure that these cases victims are supported to ensure that they will take these cases through, to ensure that this law can be effective in delivering what it's intended to deliver.
Thank you. And just finally, Chair, and thank you for your patience with me. Just to go back to the legacy one, and this is asking an opinion, I suppose, more than anything factual. But would it be fair to say that if the British government do bring forward the proposed statute of limitations, then ongoing prosecutions will fall?
I've absolutely no idea. I would need to see the terms of anything that was brought forward.
Okay, and I suppose we're all in the same position on that. None of us have actually seen anything. But I appreciate your answers to the questions, and as I said at the start, I wish you all the best in the future, and thank you very much for coming to the committee today.
Thank you very much, Linda.
Rachel.
Thank you, Chair, and thank you very much, Sir Declan, for your great introductory remarks, and also for expressing your opinions. We all have many beans in our bonnets, I would say, and I was listening as well, so look forward to working on that in the future. I too wish you a long and happy retirement. I'm sure you're looking forward to it. I had a question just about rape myths, but Linda has already covered that. So just with regard to the Gillen review, and then I have a couple of questions on the domestic abuse, if that's okay. So just about my one on Gillen, it was chapter 14 of Gillen, which was concerning the voice of the child. And there were several recommendations for the judiciary to consider in terms of case management. And that was 189 and 190, and it was about child complainants and offering an obligatory case management hearing, and also ground rules hearings to be introduced in all involving child complainants or vulnerable adults. So would you have any information or an update on the work to implement those recommendations?
Well, I know that work has been taken forward within the family division. I'm not across the detail of exactly what the most recent numbers are in terms of statistics of the cases in which that has occurred, but I am clear about the fact that within the Shadow Family Justice Board, that work has been taken forward, and I'll certainly ensure that it's forwarded through to you after this hearing, so that I can give you a full answer.
Thank you very much. That's much appreciated. Sorry to put you on the spot.
No, that's all right.
And I'll move on then just to domestic abuse. There's a lot that I would like to ask you about this, and I'll try and be as succinct as possible. But we obviously discussed as part of the domestic abuse and civil proceedings Act in the committee deliberations about training and about awareness, coercive control, and about across the justice system, and that included all criminal justice partners, and about judiciary. We heard loud and clear from a lot of representatives from organisations and about issues with child contact orders and about how the perception of the courts were on the ground. So in terms of training, has there been any training or other work within the judiciary in terms of domestic abuse, say myths on domestic abuse, or any on child contact orders in the case of domestic abuse and coercive control?
Yeah, I mean, this is an issue which has been troublesome from our point of view for really quite some time. I know that I went down to the Foyle Women's Aid Centre with David Ford when he was Justice Minister, and we met Mary Brown and others who were involved with that project. And we had a long discussion about what would work in terms of the general, if you like, strategic approach as to how one should deal with this. In an awful lot of cases, the person abused would really quite like to get back the person with whom they initially formed the relationship, because that person was a person whom they loved, therefore, and I think this was supported by Mary and others, that finding ways of getting perpetrators engaged with what they'd done and understanding it, and seeing whether or not, depending on the circumstances obviously, but whether or not it was possible to achieve an outcome, became somewhat controversial, because there has to be an element of stick, but there also has to be an element of carrot in order to make this happen. Now, what happened was that eventually, in discussions with the PSNI, the deal was that the perpetrator had to accept criminal liability, and only then would the perpetrator have the opportunity to engage in a perpetrator's course. And we're not talking about, this is in domestic abuse, certain domestic abuse cases, not all. I mean, there were cases that were simply far too serious where none of this would arise. And I mean, broadly what happened was that those who were before the court were advised that they should plead not guilty, and the high likelihood was that the case wouldn't be proceeded with against them, and that's what happened. And that pilot didn't turn out to be successful. So what we did was, with the money that we secured for that pilot, we then transferred it by agreement over to the family law system, because in family law the same problem arises. It hasn't reached the criminal justice stage, but it's there as an issue within the family. And they had much more success in getting perpetrators to engage in perpetrators' programs. And we then transferred that money over to the family side in order to increase the number of people who could be dealt with in perpetrators' programs there. So that's stage one, as it were, and we can put that to one side. The second element has been the programme which was run as a pilot by District Judge McElhone, Barney McElhone in Derry, and it was his work that actually demonstrated the problems with the existing domestic abuse court, and also, I think, focused on what you need to do in order to make a court of this sort work. So you needed to have special sitting, it needed to be regular, you needed to have a range of supports available, both from those provided by agencies such as social workers and others, but also the support that you would get from organisations such as Foyle Women's Aid, who were able to provide emotional and other practical support to victims who were in this sort of situation. And as a result of that, when the proposal came forward to lead something in Belfast Magistrates Court, the presiding district judge, Judge Bagnall, prepared a paper on a specialist domestic violence court for the department. And the point that she made was that there were things that everybody would have to put together. So it would involve, for instance, the police would need to provide PPS with high quality body-worn footage, which could be capable of it being admitted in evidence. Priority needed to be given to files so that they could be generated through as promptly as possible with the PPS together with the evidential materials. And that would require a discussion between PPS and PSNI about that priority. That the evidence should be served at an early stage, and judgments made about ensuring that special measures were available for the victims, so that you had a different point of entry into the court building. The victim felt secure, was protected from any form of intimidation. That in cases where these cases can arise in any circumstance, of course, so they can suddenly turn up in any court on any day. And the point is that they would then be referred immediately to the next domestic violence court, which would be that week. You know, you'd be within a week. And the important thing there was that that's where all the supports would be, to provide the support for the victim. And the same judge who sat in the review court would then actually deal with the hearing of the offence itself, that the prosecutors would need to be trained so that only trained prosecutors would deal with domestic violence cases, and that consultation with the complainant or the victim would take place before the court hearing, not just on the day, but before that, in order to ensure that everything was in place. And now this was just around the time of the pandemic coming into play. We also looked at the possibility of a creche facility as well within the court to facilitate those who were involved. And of course, remote evidence centres are another aspect of what we've been looking at. So, I mean, this was a judicially led approach as to how we could start to deal with this problem and actually build on the work that Barry McElhone had done in the Northwest and see if we could translate it into that bigger area in Belfast. And I don't believe that has yet been put in place.
November they hope to start that process.
Mandy has helpfully told me that in November they hope to start that. But I mean, this is a very important piece of work. It shows that you need to have everybody joined up. You need to ensure that the personnel are in place. You need to ensure that the arrangements are understood by all of the actors in order to ensure that we provide for these victims the support that we need to provide.
Thank you very much, Jack. That was a very full answer, and thank you very much for the clarification on the date. I had a question down about what your thoughts around introducing a constant dedicated specialist domestic abuse court, but I don't need to ask you that anymore because you didn't cover that. So thank you very much. My last question, Chair, is just sort of returning on the theme of sort of culture and myths within the courts, and it's regarding to domestic abuse, and just it's in relation. You might not be able to answer specific questions, and I absolutely appreciate that. But I had been contacted by a professional who works with survivors of domestic abuse, and the myths around domestic abuse are evident to them in some of our courts. And I'll give you an example, and it was a complaint that had been brought to my attention, and the survivor of domestic abuse, in applying for a non-mall, was criticised by a judge, among other things, for not reporting incidents to police. not leaving their home to protect themselves, and for being victimised when, as she was a highly educated person. Now this person was applying for a protection order against her abuser, and according to what I've been told, the court considered the possibility of not providing that protection because the judge was unsure as to whether the applicant would actually call the police if and when the perpetrator would maybe breach the order. But so just to my actual question, in a very long-winded way, I appreciate that. When somebody complains about the conduct of a member of the judiciary or a judge, how is that taken forward within your office, if it is, and what actions could be taken on behalf of that victim?
Well, we have a complaints policy which deals with things that judges do which are outside the hearing of the case. If it's to do with the hearing of the case, then the procedure is to use the appeal process. I mean, certainly the scenario that you have described is one that I would be very disappointed by, because it doesn't sound to me as though it even begins to recognise the position of the victim.
Thank you, Sir Declan, and I wish you all the best. I really appreciate your answers and your time today. Thank you, Chair.
Thank you. Peter.
Thank you, Chair. Thank you, Sir Declan. As with others, I thank you for being here and wish you all the best in terms of retirement. I was reflecting, as you were making your opening remarks, I suddenly realised that I've reached the depressing stage in life where not only having gone past the stage where all sports people are, generally speaking, younger than me, and frequently come across school principals who are younger than me, we're now steadily reaching to the position where the new Lord Chief Justice is younger than me, which is not a happy time to reach in life in terms of age. So that, I suppose, just I want to probe perhaps 2 or 3 areas, just I suppose following up, and I may well ask you your opinion on a couple of things, which I know at that point the beads of sweat suddenly start going down any witnesses, particularly a judge's back at that point. You made some, I think, some very pertinent points early on when you were talking about modernisation, and I think part of the issue, I suppose, is, first of all, and I welcome particularly, for instance, the tasking of John Gillen, if you liked, following in the footsteps of Lord McDermott, it was about 45 years ago, roughly. And I suppose one of the things when looking at modernisation, and also I think it's important in terms of the vision statement that's been outlined, and indeed the changes that are there in terms of the committal proceedings, and it strikes me, while obviously we need to ensure that protections are there, you know, the concept of, for example, simply bringing prisoners on remand this long distance, sometimes for a mention in court for a few seconds, and then being wheeled away by the police in handcuffs, seems to be sort of clearly sort of outdated in terms of modern technology. But I suppose part of the issue is also to ensure that where what is put down doesn't simply become something in a glossy brochure, maybe to draw the analogy. And I was very struck, which I think maybe the committee may seek to follow up as well, from what you said earlier in terms of the COVID regulations, that there will be a natural, I think, rush is maybe the wrong word, but there'll be a natural inclination to see where there's been restrictions that have been placed, to simply roll back the restrictions, remove them. And I suppose in doing that, I think one of the things that we need to be conscious of, and particularly within the judicial system, is that in following that very natural desire that we don't take what are virtuous changes that have arisen as a result of that and simply roll back. So I think we will need to engage with the Minister, and I suppose indirectly there via the Executive, that if there's a broader rollback of COVID restrictions, that where there are advantages to some changes, that we need to make sure those are captured. But what about the first question then really is, it's fairly clear that in terms of some of the remote work that will be there, that has arisen from COVID, and again, it strikes me that it would be a bit of a nonsense if simply we repealed various things to then seek very quickly to reintroduce them. Obviously, people have highlighted the advantages of the remote working that has happened through COVID. I just wonder if there are any other areas where you feel that there have been advantages to the system, maybe not even ones that were initially contemplated, arising out of the restrictions which you feel would be very valuable to retain in the immediacy of a sort of as we gradually move out of COVID lockdowns?
I mean, I think as I said at the start, the biggest cultural change in a way that has happened is, I think anyway, is the extent to which all the elements of the justice system have recognised that they need to work together. And I think as a result of that we have a much, much better understanding of what our strengths and weaknesses are in the sense of what we can do and what we can't. I mean, to make things happen within the justice system, if it's criminal justice, you have to have, the PPS have to have the resources to do what it is you want them to do, as do the PSNI. The defence have to have the materials that they need in order to make sure that it happens. And I think that the way in which that we have attempted to engage with each other through this COVID period has been eye-opening in terms of understanding that you can't just say, I want X, and then not think about how is that other person going to be able to, or that other organisation, how are they going to be able to do it?
So Declan, I suppose you've clearly recognised that. Do you think that has been a lesson that has largely speaking dawned across the system, or is there a danger as we move? The danger obviously is, as people sort of talk about returning to normal, that we don't bank the gains where they are. And is there a danger of people sort of backsliding, if we can put it that way, into a little bit more of a silo mentality?
I mean, I can't imagine that people would that would happen because it has become so apparent that there are positives to be taken out of that. And part of the positives are that instead of not talking to each other and then finger pointing and blaming somebody for not producing something or other, you sit back and you look at, well, what do we have to do to make this work? And do we have to give some priority to somebody else rather than us in order to do it? And I think the advantages of that have become so apparent to everybody involved in the system that I would be astonished if the system allowed that to happen.
The second issue maybe I want to probe, it's again something, times have been highlighted in Northern Ireland, it's a much wider debate, particularly across general Western democracies, is I suppose the issues around separations of powers between judiciary, between legislature and executive.
Yeah.
And at different times the accusations, again depending upon people's perspective, has either been that either legislature or executive have tried to infringe upon judicial independence. On the flip side of the coin, those coming from either legislative or executive position have seen what they would see as a certain level of judicial overreach and a level of a feeling that if you like that their powers are trying to be circumscribed when they are effectively they're representing people in that way. But just maybe want to give you the opportunity if you want to maybe comment on where you see the balance with that and where you see the debate developing.
Well, I suppose probably not answering the question directly, but I think one of the
you want to swap seats too?
I think one of the things that I'm conscious of is that if you look at, let's take a controversial case like Nicholson, was the right to die case, which involved a lot of very sensitive, obviously very sensitive issues. One of the things that was clear, and I'm looking at this now as a lawyer rather than the rights and wrongs of the position in relation to that unfortunate man, but what the court said in that case was really quite important in terms of what the Human Rights Act appears to mean. And what the court said was that, yes, the issue as to whether there should or should not be a right to be able to have assistance in order to commit suicide, in order to kill yourself, was a matter for the legislature in the Suicide Act, which made it illegal to do that, was a matter for the legislature. But as the court put it, This was an area where Article 8 rights, that's rights to private life, was involved, and that it said that there was a shared competence on the part of the court in that area as well. So the court asserted that the effect of the convention was that in this political area, each had competence, and the court's competence wasn't the same, of course, as the competence of the legislature, because the legislature could actually do something. They could change the law. The court couldn't do that. The court could declare the law incompatible, but wasn't able to change the law. Now, the $64,000 question is, why were the views of the 9 judges more important than the views of 9 other citizens? In other words, why should the judges have a competence to declare that law incompatible with human rights, and therefore something that if you like, should be changed in order to comply with human rights? In a sensitive issue of that nature, is that the kind of territory that the courts should be in? I think that's a difficult question. And I think the courts have struggled with it, because if you look at a whole range of cases that have come even from this jurisdiction in the human rights, Northern Ireland Human Rights Commission's appeal to the Supreme Court in relation to reproductive rights, 4 of the judges said this is not for us, including the present President of the Supreme Court. Similarly, in Nicholson, 2 of the judges said this isn't for us. So, I mean, this debate is not settled. It's clear that there are differing views on where the competences lie. My predecessor was quite clear about where he was in all of this, and I don't think he thought that anything was outside the competence of the Supreme Court, and that's a view that was shared by some others as well. For my own part, I don't think you can now take a confident view of where these matters are going to go. I mean, I think the President of the Supreme Court, in his submission to Lord Fox's review, made clear that he recognised that there was a need for the judiciary to recognise legislative competence and to be careful not to step over the line in relation to that. What that actually means, I'm not entirely sure.
Maybe finally, I suppose, slightly put you on the spot, and appreciate that there may be certain things you'll want to say privately, but as you move towards retirement, I know maybe, shall we say, probably the buzzwords these days now is a new phase in your life rather than necessarily retirement.
Yep.
What advice would you give to your successor?
I think the principal thing I would say is to that judges need to engage. There are many elements of the community out there, including this committee, who have much to say about and much interest in the way in which the judicial system works. I think that 20, 25 years ago, judges would have hidden and been isolated and would not have engaged. I think those days are way over. And I think that engagement both in this environment but also with all of those other elements of the justice system and the wider community out there are now critical. Judges need to play their part in letting people see that this is a justice system in which they can have confidence.
I mean, from that perspective, and I know this goes wider than simply judiciary, is there a danger of people becoming a little bit cocooned?
Cocooned in...
Well, in the sense, look, I was struck many years ago being at an event where myself and another representative were at, and we went, I'll not name the event or the two events, both of us happened to be at one particular event and were then at another event of a particularly very different social environment, say roughly speaking, within about 10 miles of that. It was within the same constituency. And it did strike me that, and this again goes well beyond, as I said, the judicial side of things, but that apart from the two of us that were at that, the people in one event would never really come into the world of the other group of people. And I suppose it's maybe a kind of specifically towards judges, but maybe more generally towards a lot of us in society, as to whether we reach a point where we all are in danger at times of moving in a certain level of bubble.
Yeah.
And we therefore draw conclusions from that as to what is happening within the world, but that is maybe a very cosistant view of it, from whatever direction.
Yeah, I agree with that. I mean, one of the things that I sought to do was to try to reach out to engage with all of the communities within Northern Ireland, and I think that's something that we continue to need to do. Sometimes it's difficult to persuade people that they should have you along. I mean, I was grateful for, it was a little time ago now, that I managed to get invited to an event at the Skynos Centre in East Belfast, which was an opportunity that I was grateful to have in relation to meeting ordinary members of the community in that environment. And I think, your point is well made in that, there is a danger that everybody involved in the justice system is seen as a bit disconnected from the realities of life for the ordinary members of the community. I mean, we need to be conscious of that and to do what we can to ensure that people can see that our feet are firmly on the ground.
Thank you, Chair.
Thank you, Peter. And we have Gemma.
Thank you, Chair, and thank you to Sir Declan. He's lovely glad to know. I just have one question. Everything else has been covered. And sorry, my camera was off there. So just my one question is, what engagement have you had with the Westminster Review of Judicial Reviews, and what is your view of their proposed Judicial Review Bill?
I think I can probably deal with this fairly easily. We put in a response which was written largely by Lord Justice McCluskey, which indicated that we felt that the judicial review system in Northern Ireland seemed to work pretty efficiently. We noted the Fox report's suggestions, and we didn't see that there was, subject to the controversy that there is at the moment in relation to what's called the Cart case, where the reviewer, or the Lord Fox, says that there was some misleading in terms of the figures that were produced to the committee, but we were perfectly content with the outcome so far as it affected us, and we don't really think that at the moment that there's any need to go beyond what the Fox Committee has found. I mean, this was a committee of perfectly competent and able people who were selected to look carefully at this issue, and it doesn't seem to me that that there's any particular need to go beyond that. If the Lord Chancellor brings forward other proposals, then obviously I or my successor will comment on them.
Okay, thank you very much, and I too want to wish you a long and happy retirement. Chair, that's all my questions. Thank you.
Thank you very much.
And finally, we have Doug.
So Declan, first of all, thank you for giving so much of your time today and so much of your time over many years. I think you've been exceptional, and I, like the rest, really hope that you have a really enjoyable future, whatever that may entail, and whatever captures your imagination in the years to come. I was going to, I mean, a lot of the questions I was going to ask have been asked, and that's always the beauty of going last, I suppose. But I was going to ask about the family courts, and there's a lot of angst out there in the family courts that court orders, when they're in relation to child contacts, aren't really acted upon. But if court orders, when in relation to sort of assets or anything like that is acted upon seem to be more speedily. And I was just wondering if you had given any thought to reform of the legal aid for to change it in the family courts to take away that issue of one family member, for example, getting legal aid and the other one not, and just perpetuating the issues that you can get in the family courts because of that very reason?
No, I think you're quite right about to raise this issue because it is troublesome. I mean, sometimes parents just simply cannot see the wood for the trees in relation to their arrangements for their children. And from the point of view of somebody who is not a legally assisted parent, facing a legally assisted parent in circumstances where there is ongoing dispute between them, I mean, there is, I think, a pretty obvious imbalance which arises in relation to their standing. The legally aided person can afford to pursue whatever legal right they can persuade the Legal Aid Committee to support them on. The self-funding parent is, I'm afraid, in many circumstances left in a situation where, and I've seen this myself on a number of occasions, where they really can't afford legal support anymore, and they actually then have to become personal litigants. And being a personal litigant in your family dispute, where you have all the emotional baggage that inevitably go, I use baggage neutrally, but all the emotional aspects that go with that, I think is extraordinarily difficult. So I agree with you that this is an issue that certainly if we can find some form of legislative solution for or other practical solution for, then I certainly would want to assist in any way I could.
And do you think there is that solution out there, Sir Declan? Do you think there is a solution out there? Is there something innovative? You know, will your replacement, do you think, look at that as something that we could progress in maybe the next mandate, or is there still imaginative thinking still required?
Well, I wonder about that. I mean, you know, I mean, I don't want to point the finger in other directions, but I do wonder whether there might be a mechanism. I mean, you know, with these things, sometimes what you need to look at is not just the legislative solution, but also whether or not you can introduce procedures that might be more effective. Now, I imagine that the Family Court, for instance, will have attempted mediation and other ways of trying to deal with it, and that probably has been ineffective. But I do wonder whether, you know, in that type of situation, that it may be necessary for legal aid authorities to take a very close look at what they should be funding and what they shouldn't be funding. And I mean, where you know, where you're in this situation and it is on the verge of becoming abusive, then it seems to me that there may be something to be said for trying to talk in a practical way with the legal aid authorities about how they should approach this.
And would that be like going down the GB route, Sir Declan, then? Because I think they've removed it, I believe, haven't they, from their family courts? No longer.
I must say, I think that would be definitely a retrograde step in terms of removing funding, because the funding that is provided, often for both parties, is extremely helpful in ensuring that there is a resolution of the issues and is much to the benefit of the children and the parties at the end of the day. What I'm talking about is taking a very close look at those circumstances where you are being faced with any kind of repetitive litigation or prolonging of litigation, and it seems to me that there might be something to be said for just understanding that the award of legal aid funding should be proportionate to the issues involved, and people certainly shouldn't be funded to come and, you know, make a nuisance of themselves to their former partner.
So, thank you very much, and best of luck to you in the future. Thank you, Chair.
Thank you.
Thank you very much, Doug. And Sir Declan, that brings us to a conclusion. And it was once said, you have to put off being young until you retire. So I trust that you will find your renewed youth as you retire.
Well, that's very kind of you.
And thank you for your contribution today. Can you also take our best wishes, because this week you have appointed 2 new County Court judges?
Yes.
And can you pass on to them our best wishes on their elevation, and wish them well in their new roles? And thank you again, and we wish you well. Randy, thank you as well for being with Sir Declan. Thank you.
Thank you very much.
Okay, thank you. Members, just a couple of things that we want to just to tidy up, and really following on from the presentation from Sir Declan, it might be useful for us to get an update on the estate strategy in terms of courts, if we're agreed, just to see where all of that is at. Also, would you have any view as to whether or not we should just ask the department for their comment in relation to a non-ministerial department? It might be interesting to see what we would get back, given it was Sir Declan's bee. My worry is it's not somebody who has a bee in their bonnet, it's when they have a hive. And that really can become rather challenging. So if you're agreed, we might just ask the department in relation to that. And also, I think the point that was made by Peter, because it is worrying. I've heard a few comments in some other departments that there is now a tendency to start clawing back what they had pre-COVID. And I think some departments are beginning to re-establish their credentials. So if there's been good practice established, then I think that good practice should be retained and built upon. So maybe it might be useful for us to ask the department what will, in their view, what has been established as good practice, whether it is in regards to the remote hearings, and what of those are going to be retained, so that we get some sense and picture where some of those things are. Happy enough?
Agreed.
Yep, thank you. Correspondence, members, and it is really only, there's 7 items of correspondence. There's one that just draw to your attention. It's a women's policy. It's page 745. It's the Women's Policy Group and an invitation to attend the relaunch of the COVID-19 Feminist Recovery Plan on Wednesday, 28th of July. And that's just if members would let the committee office know who would like to attend, so that the necessary arrangements can be made. There's an item, Chairman's Business, and I suppose the only thing I want to say is we had written as a committee to the Minister, following on from last week's meeting in relation to the Justice Bill. I, along with the Vice Chair, met the Minister on Monday, had a further conversation with the Minister later, or on Tuesday I think it was, had a discussion with the First Minister, and I think we landed at a place where today at the Executive, I understand, a Justice Bill, a revised Justice Bill was approved. So we will now see the sight of that, I hope, very soon, and we'll start to make. Now, my understanding is that it basically narrows down the bill, what was, I think, the place where the committee was at anyway, to focus on the issues that need it to be the focus, particularly in relation to Sir John Gillen's report. And so we'll now have landed ourselves with some more work, but I think that it's work that's worth doing. It's the right thing to do, and we will see the detail of that. And hopefully by the meeting next week, we'll have more detail in relation to that. So that's hopefully progress. Any other items of business? Oh, Linda.
Thank you, Chair. Just in relation to a couple of issues. The first one is on the Justice Bill. I would certainly be more than happy to see that coming forward. I think I've raised it enough times. I don't need to go over all the reasons why I want to see it coming forward. I probably am slightly disappointed that it's going to be a revised bill. We wanted the bill. I believe that there was a lot of stuff in it that was important, and But what we need now is to see the bill in front of the committee and see what's in it and ensure that we get through it. I also think it's important that we see what's not in it. If the department can provide us with that, what's not in the bill, so that we can look at and question them on how those issues will be progressed, because we did talk at great length as a committee numerous occasions around the important issues that we want to see in the Justice Bill. So I think it's important as a committee, if it's possible, for us to see what is now not going to be in that bill, so that we can look at that and see what other avenues or how those issues will be remedied. So thank you.
Okay, Rachel.
Thanks, Chair. No, my comments were very similar to Linda's. I'm just a bit surprised to hear about a revised bill. I'm not really too sure why, but that's for other people to decide on and not me. So I would certainly welcome any information about what's not going to be in it. Are we talking, Chair, apologies, you may have some more information on it than I do, but we're talking now that it'll not be a miscellaneous bill, but it'll be about Gillen review instead.
I get the sense that was following on from the conversation, that was what the focus would be, that it would be more specific as opposed to being a miscellaneous bill that opens up the opportunity for the department to bring everything that it wants to bring and make it a larger bill than what was maybe necessary. In the time that we have, given the fact that we're at this particular juncture in relation to the mandate. But again, I don't have all the detail, and that's why I think we should find out what's in it and what's not in it, so that because this committee has had, from what I can gather, a pretty extensive exchange in relation to the issue over a period of time. So.
Yes, thank you, Chair. No, I think we've been waiting on this bill since last year, so it's certainly something we've continually raised. So we're looking forward to getting to it. I would just have concern. I know that there was. An agreement set with the likes of positions of trust legislation. Would that be something that would still be in it? And if not, why not? So I would definitely welcome some more information on that. Hopefully the executive can sign off on that amongst the other bills that are currently awaiting sign off. Okay. And we can certainly scrutinise that, as is our job, as and when we get a hold of it. But thank you.
Thank you. Okay, just one other item, members. Are you just content? I need to clarify this. You're content with the actions and the remaining items of correspondence as set out in the cover sheet, or whether there are any other comments you wish to raise? Content? Okay, that brings us to the conclusion, which is the time and place of the next meeting. Just to remind members that we had agreed a joint meeting that will be held with the Health Committee at 1 p.m. on Thursday, the 1st of July, and then the next meeting of the committee will then be at 2:30 on the 1st of July in room 30 here in Parliament Buildings. Members, thank you for your attendance.
What meeting?
Sorry,
is it also in room 30?
We're sorting out the arrangements.
No, the arrangements for the joint meeting will be sent out to you as soon as they're finalised. Can I thank Peter for being in attendance here, kept me seeing along with the staff, and to the members who zoomed in, if I ever am seeing, but I don't know about that. Yeah. But thank you again for your help, and we'll see you all being well next week. Thank you.
Sure. Can we just welcome Peter and Robin to the committee? Sorry, I did that earlier in the meeting.
At least I can reassure Jabba I won't be closing any more schools while I'm here.
Okay. Thank you.
This is the Northern Ireland Assembly Senate Chamber Programme Sound.